with the offense of false report. This offense embraces the lesser included offenses of attempt to commit false report. Count 19 of the presentment charges the defendant, Megan Boswell, with the abuse of a corpse. This offense embraces the lesser included offense of facilitation of abuse of a corpse and attempt to commit abuse of a corpse. Count 20 of the presentment charges the defendant, Megan Boswell, with the offense of failure to report a death under suspicious, unusual, or unnatural circumstances. This offense embraces the lesser included offense of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The presentment in this case is the formal written accusation charging the defendant with these charges. It is not evidence against the defendant and does not create any inference of guilt. To this presentment and each offense charged and included therein, the defendant has entered a plea of not guilty. The evidence in this case has been completed and final arguments will take place momentarily. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks that I have made, do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. As to any question to which an objection was sustained, you must not speculate as to what the answer might have been or as to the reason for the objection, and you must assume the answer would be of no value to you in your deliberations. You must not consider for any purpose any offer of evidence that was rejected or any evidence that was stricken out by the court, such matters to be treated as though you had never known it. You must never speculate to be true any insinuation suggested by a question asked of a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. Whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural unless clearly inapplicable. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman. The law presumes that the defendant is innocent of the charge against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A conviction cannot be based on conjecture, suspicion, or a mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof to an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim. It is not speculation or suspicion. It is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. The state must have proved beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by the defendant before the finding and returning of the presentment in this case. The date of the offense is not an essential element of any of the offenses charged in the presentment or any lesser included offense. The state is not required to prove beyond a reasonable doubt a specific date upon which any of the alleged offenses occurred. The state is only required to prove beyond a reasonable doubt that the alleged offenses occurred before the finding and returning of the presentment in this case. The burden is upon the state to prove by preponderance of the evidence that this offense was committed in Sullivan County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that this offense was committed or consummated in Sullivan County, Tennessee, then you must return a verdict of not guilty. If you have read or heard anything about the case other than in open court, you should disregard what you read or heard and base your verdict only upon the law and evidence presented under the direction of the court. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. You are the exclusive judge of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile them if you can, without hastily or rashly concluding that any witness has sworn falsely, for the law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to the proof, if any, of his or her general character, the evidence, if any, of the witness's reputation for truth and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, if any are shown, and all the evidence in the case tending to corroborate or to contradict him or her. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance to his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it's corroborated by other credible testimony or by the facts and circumstances proved in the trial. Your decision on the facts of this case should not be determined by the number of witnesses testifying for or against a party. You should consider all of the facts and circumstances in evidence to determine which of the witnesses you choose to believe or not to believe. The defendant has the right to remain silent, that is, the right not to testify. You shall not consider such silence as evidence of guilt, and you can draw no inferences of guilt from such silence or decision not to testify. You are reminded that the state has the burden to prove guilt of any offense beyond a reasonable doubt. Evidence has been introduced in this trial of a statement or statements by the defendant made outside the trial alleged to show an admission against interest. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also, consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider it with all the other evidence in the case in determining the defendant's guilt or innocence. Expert witness. During the trial, you heard the expert testimony of Dr. Matrina Schmidt, who was described to us as an expert in the field of forensic pathology, Dr. Darinka Polchan, who was described to us as an expert in the field of forensic pathology, Paul Durant, who was described to us as an expert in the field of forensic analysis of digital devices, Marla Gray, who was described as an expert in the field of serology and DNA analysis, and David Hoover, who was described to us as an expert in the field of latent fingerprint identification. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Evidence. You may have heard two types of evidence in this case. One type of evidence is called direct evidence, and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The law makes no distinction between the weight that you should give either direct or circumstantial evidence. It is for you to decide how much weight to give any evidence. The crime charged or included in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be convicted or acquitted on any or all of the offenses charged or included. Your findings as to the crimes charged must be stated in your verdict. You will not be provided with a transcript of the testimony. However, you were permitted to take written notes. Notes taken by a juror to be used only as an aid to the memory of that juror alone and may not be used as authority in the jury deliberation room. The fact that something has been reduced to writing does not make it more significant than matters not noted down, and does not make it more accurate than independent memory. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including all social media, to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. The court will now instruct you as to the law applicable to all counts of the presentment. Count 1, premeditated first-degree murder. Any person who commits the offense of premeditated first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, that the killing was premeditated. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. If you find from the proof beyond a reasonable doubt that the defendant is guilty of premeditated first-degree murder, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of premeditated first-degree murder as charged in the presentment, then your verdict must be not guilty as to this offense. Count 2, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child abuse, that is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated child abuse. The following essential elements apply to aggravated child abuse. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child abuse. The killing may precede, coincide with, or follow the aggravated child abuse and still be considered as occurring in the perpetration of the aggravated child abuse, so long as there is a connection in time, place, and continuity of action. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony, as charged in the presentment, then your verdict must be not guilty as to this offense. Count 3, first-degree murder in the perpetration of a felony. Any person who commits first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the killing was committed in the perpetration of or the attempt to perpetrate the alleged aggravated child neglect. That is, that the killing was closely connected to the aggravated child neglect, the alleged aggravated child neglect, and was not a separate, distinct, and independent event. And 3, excuse me, 3, that the defendant intended to commit the alleged aggravated child neglect. The following essential elements apply to aggravated child neglect. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And 2, that the act of neglect resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. Knowingly and intentionally have previously been defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of first-degree murder in the perpetration of a felony, then the jury will not fix a fine. If you have a reasonable doubt as to the defendant's guilt of first-degree murder in the perpetration of a felony was charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly means that a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally has been previously defined for you on page 13 of these instructions. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of second-degree murder, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as the defendant's guilt of second-degree murder is charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation sufficient to lead a reasonable person to act in an irrational manner. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has been previously defined for you on page 17 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation, sufficient to lead a reasonable person to act in an irrational manner. If you find from the proof beyond a reasonable doubt that the defendant is guilty of voluntary manslaughter, then you may fix a fine in any amount not greater than $10,000, and you will so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of voluntary manslaughter as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also shown or established if it is shown that the defendant acted knowingly or intentionally. Intentionally has been previously defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 13 of these instructions. Knowingly has previously been defined for you on page 17 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless homicide, then you may fix a fine in any amount not greater than $5,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of reckless homicide as charged and included in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, and 3, criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim would be killed. The risk must be of such a nature and degree that his failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly. Intentionally has been previously defined for you on page 13 of the instructions. Knowingly has been previously defined for you on page 17 of these instructions. Recklessly has been previously defined for you on page 19 of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of criminally negligent homicide, you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have reasonable doubt as to the defendant's guilt of criminally negligent homicide as charged and included in the presentment, then your verdict must be not guilty as to this count. Lesser included offense counts 1, 2, and 4, child abuse. Any person who commits child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child abuse, you may fix a fine in any amount not greater than $2,500, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 3, and 5, child neglect. Any person who commits child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare and 2, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of child neglect, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 4, aggravated child abuse. Any person who commits the offense of aggravated child abuse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury, and 2, that the act of abuse resulted in serious bodily injury to the child, and 3, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Child and serious bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child abuse as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For purpose are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated assault, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. Excuse me. If you have a reasonable doubt as to the defendant's guilt of aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 4 and 5, reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another, and 2, that the act resulted in serious bodily injury. For the purpose of this count, recklessly bodily injury and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of reckless aggravated assault, then you may fix a fine in any amount not greater than not greater than $5,000. And you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of reckless aggravated assault as charged in the presentment, then your verdict must be not guilty as to this offense. Ladies and gentlemen, anytime that I make a change, I'm making the change in the notebook that's black. It says original charge. This is the official original charge. Those are just your copies, okay? Lesser included offense counts 1, 2, 3, 4, and 5. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to another, and 2, that the defendant acted either intentionally, knowingly, or recklessly. For purposes of this count, intentionally, knowingly, recklessly, and bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of assault, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of assault as charged in the presentment, then your verdict must be not guilty as to this offense. Lesser included offense counts 1, 2, 3, 4, and 5, misdemeanor reckless endangerment. Any person who commits the offense of misdemeanor reckless endangerment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. For purposes of this count, recklessly, intentionally, knowingly, and serious bodily injury are defined for you in the definition section of these instructions. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. If you find from the proof beyond a reasonable doubt that the defendant is guilty of misdemeanor reckless endangerment, then you may fix a fine in any amount not greater than $2,500, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of misdemeanor reckless endangerment as charged in the presentment, then your verdict must be not guilty as to this offense. Count 5, aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare. And two, that the act of neglect resulted in serious bodily injury to the child. And three, that the child was 8 years of age or less. Knowingly has been previously defined for you on page 15 of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Intentionally has been previously defined for you on page 15 of these instructions. Adversely affect the child's health and welfare, child, and serious bodily injury are defined for you in the definition section of these instructions. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child abuse, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. That should say neglect. All right, let me reread that. If you find from the proof beyond a reasonable doubt that the defendant is guilty of aggravated child neglect, then you may fix a fine in any amount not greater than $50,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of aggravated child neglect as charged in the presentment, then your verdict must be not guilty as to this offense. Count 6, tampering with evidence. Any person who commits the offense of tampering with evidence is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knew an investigation was in progress, and two, that the defendant concealed a thing with the intent to impair its availability as evidence in the investigation. For purposes of this count, knew, conceal, destroy, and bodily injury are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of tampering with evidence, then you may fix a fine in any amount not greater than $10,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of tampering with evidence as charged in the presentment, then your verdict must be not guilty as to this offense. Count 7 through 17, false report. Any person who makes a false statement to law enforcement officer is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the statement was made by the defendant. Two, that statement was made in response to a legitimate inquiry by a law enforcement officer. And three, that the statement would concern a material fact about an incident within the officer's concern. And four, that the defendant knew such statement was false. And five, that the statement was made by the defendant with the intent to obstruct or hinder the officer from preventing an incident from continuing to occur. For purposes of this count, new and law enforcement officer are defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of false report, then you may fix the fine in any amount not greater than $5,000, and you so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt in a false report as charged in the presentment, then your verdict must be not guilty as to this offense. Count 19, abuse of a corpse. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond reasonable doubt the existence of the following essential elements. 1, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person. And 2, that the defendant acted without legal privilege. And 3, that the defendant acted knowingly. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond a reasonable doubt that the defendant is guilty of abuse of a corpse, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of abuse of a corpse as charged in the presentment, then your verdict must be not guilty as to this offense. Count 20, failure to report a death under suspicious, unusual, or unnatural circumstances. Any person who commits the offense of failure to report a death under suspicious, unusual, or unnatural circumstances is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly failed to report the death of Evelyn Boswell to the county medical examiner, local police, district attorney, or sheriff. And 2, that the death was from violence, trauma, or any suspicious, unusual, or unnatural manner. For purposes of this count, knowingly is defined for you in the definition section of these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. If you find from the proof beyond reasonable doubt that the defendant is guilty of failure to report a death under suspicious, unusual, or unnatural circumstances, then you may fix a fine in any amount not greater than $3,000, and you'll so report your fine on your verdict form. If you have a reasonable doubt as to the defendant's guilt of failure to report a death under suspicious, unusual, or unnatural circumstances as charged in the presentment, then your verdict must be not guilty as to this offense. Criminal attempt. The following definition applies to the attempt to commit any criminal offense that is charged or included as a lesser offense in these instructions. Any person who attempts to commit any criminal offense is guilty of a crime. For you to find the person guilty of criminal attempt to commit any criminal offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specified criminal offense, and 2, that the defendant did some act intending to complete a course of action or cause a result that would constitute the specified criminal offense under circumstances as the defendant believed them to be at the time. And his actions constitute a substantial step toward the commission of the specified criminal offense. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his intent to commit the specified criminal offense. The essential elements necessary to constitute each specified criminal offense are set out in these instructions. The definition of attempt to commit a criminal offense and the fine associated with each attempt to commit a criminal offense is as follows. Count 1. Attempt to commit premeditated first-degree murder, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $50,000. Attempt to commit voluntary manslaughter, maximum fine $50,000. Attempt to commit child abuse, maximum fine $50. Attempt to commit child neglect, maximum fine attempt to commit child abuse, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 2. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child abuse, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 3. Attempt to commit first-degree murder in the perpetration of a felony, maximum fine $50,000. Attempt to commit second-degree murder, maximum fine $25,000. Attempt to commit voluntary manslaughter, maximum fine $5,000. Attempt to commit child neglect, maximum fine $500. Attempt to commit assault, maximum fine $500. Count 4. Attempt to commit aggravated child abuse, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child abuse, maximum fine $500. Count 5. Attempt to commit aggravated child neglect, maximum fine $25,000. Attempt to commit aggravated assault, maximum fine $5,000. Attempt to commit assault, maximum fine $500. Attempt to commit child neglect, maximum fine $500. Count 6, attempt to commit tampering with evidence, maximum fine $5,000. Counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17, attempt to commit false report, maximum fine $5,000. Count 19, attempt to commit abuse of corpse, maximum fine $2,500. Count 20, attempt to commit failure to report death under suspicious, unusual, or unnatural circumstances, maximum fine $2,500. Facilitation of a felony. The following definition applies to any offense of facilitation that is charged or included as a lesser offense in these instructions. Any person who commits the offense of facilitation of a felony is guilty of a crime. For you to find the defendant guilty of facilitation of any offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit the specified offense, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of the specified criminal offense. And 3, that the defendant furnished such assistance knowingly. The essential elements necessary to constitute the specified criminal offense are set out in these instructions. The definition of facilitation of an offense and the fine associated with each facilitation offense is as follows. Count 1, facilitation of first-degree murder, maximum fine $50,000. Facilitation of attempt to commit first-degree murder, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 2, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 3, facilitation of first-degree murder in the perpetration of a felony, maximum fine $50,000. Facilitation of attempt to commit first-degree murder in the perpetration of a felony, maximum fine $25,000. Facilitation of second-degree murder, maximum fine $25,000. Facilitation of attempt to commit second-degree murder, maximum fine $10,000. Facilitation of voluntary manslaughter, maximum fine $5,000. Facilitation of attempt to commit voluntary manslaughter, maximum fine $3,000. Facilitation of reckless homicide, maximum fine $3,000. Facilitation of criminally negligent homicide, maximum fine $2,500. Count 4, facilitation of aggravated child abuse, maximum fine $5,000. Facilitation of attempt to commit aggravated child abuse, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 5, facilitation of aggravated child neglect, maximum fine $5,000. Facilitation of attempt to commit aggravated child neglect, maximum fine $3,000. Facilitation of aggravated assault, maximum fine $5,000. Facilitation of attempt to commit aggravated assault, maximum fine $3,000. Facilitation of reckless aggravated assault, maximum fine $3,000. Count 6, facilitation of tampering with evidence, maximum fine $5,000. Facilitation of attempt to commit tampering with evidence, maximum fine $3,000. Count 19, facilitation of abuse of the corpse, maximum fine $2,500. Criminal responsibility for conduct of another. A defendant is criminally responsible as a party to the offense charged and included if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Under the theory of criminal responsibility, an individual's presence and companionship with the perpetrator of an offense before and after commission of an offense are circumstances from which his or her participation in the crime may be inferred. No particular act need be shown, and the defendant need not have taken a physical part in the crime in order to be held criminally responsible. However, a defendant's mere presence during the commission of a crime is not enough to convict based on the theory of criminal responsibility for the conduct of another. The jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence or both, whether it exists in the evidence of the state or the evidence of the defendant. Before you can find the defendant guilty of being criminally responsible for an offense committed by the conduct of another, you must find that all the essential elements of the offense have been proven by the state beyond a reasonable doubt. Definitions. Intentionally or intent means a person acts intentionally with respect to the nature of the conduct or a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly or knew means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown the defendant acted intentionally. Recklessly or reckless means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Adversely affect the child's health and welfare may include, but not limited to, the natural effects of starvation and dehydration. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, or any physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Child means a person under 18 years of age. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty, or a broken bone of a child who is 12 years of age or less. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces the death and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death, and in such case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide if the proof shows the death was caused by an independent intervening act or omission of the deceased or another, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. However, if in the course of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. It is not necessary that the sequence of events or the particular injury be foreseeable. It is only necessary that the death fall within a general field of danger which the defendant should have reasonably anticipated. If you find that the defendant's act, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, then you must find her not guilty. Deliberation process. Each count of the presentment is a separate offense, and you must deliberate on each count. When you begin your deliberations on each count of the presentment, you must first deliberate on the indicted or charged offenses. If you unanimously find the defendant guilty of the indicted offense, you may stop your deliberations as to that count of the presentment. You would then begin your deliberations as to the remaining counts of the presentment. If you unanimously find the defendant not guilty of the indicted offense in each count, or you have a reasonable doubt, then you must unanimously find the defendant not guilty of the indicted offense, and next consider the lesser included offenses in each count as set out below and in your verdict form. You must first deliberate on the greater offense as to each count and unanimously reach a verdict as to the greater offense before you move to the next lesser included offense within that particular count. If you unanimously reach a verdict as to the guilt of a defendant as to a greater offense, you may stop your deliberations as to that count. You would then proceed to the remaining counts of the presentment until you have reached a verdict on each count of the presentment. The order in which you are to consider the charges and lesser included offenses in each count is as follows. Count 1. 1. First degree murder. 2. Facilitation of first degree murder. 3. Attempt to commit first degree murder. 4. Facilitation of attempt to commit first degree murder. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Child neglect. 19. Attempt to commit child abuse. 20. Attempt to commit child neglect. 21. Assault. 22. Attempt to commit assault. 23. Misdemeanor reckless endangerment. Count 2. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child abuse. 18. Attempt to commit child abuse. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 3. 1. First degree murder in the perpetration of a felony. 2. Facilitation of first degree murder in the perpetration of a felony. 3. Attempt to commit first degree murder in the perpetration of a felony. 4. Facilitation of attempt to commit first degree murder in the perpetration of a felony. 5. Second degree murder. 6. Facilitation of second degree murder. 7. Attempt to commit second degree murder. 8. Facilitation of attempt to commit second degree murder. 9. Voluntary manslaughter. 10. Facilitation of voluntary manslaughter. 11. Attempt to commit voluntary manslaughter. 12. Facilitation of attempt to commit voluntary manslaughter. 13. Reckless homicide. 14. Facilitation of reckless homicide. 15. Criminally negligent homicide. 16. Facilitation of criminally negligent homicide. 17. Child neglect. 18. Attempt to commit child neglect. 19. Assault. 20. Attempt to commit assault. 21. Misdemeanor reckless endangerment. Count 4. 1. Aggravated child abuse. 2. Facilitation of aggravated child abuse. 3. Attempt to commit aggravated child abuse. 4. Facilitation of attempt to commit aggravated child abuse. 5. Aggravated assault. 6. Facilitation of aggravated assault. 7. Attempt to commit aggravated assault. 8. Facilitation of attempt to commit aggravated assault. 9. Reckless aggravated assault. 10. Facilitation of reckless aggravated assault. 11. Assault. 12. Attempt to commit assault. 13. Misdemeanor reckless endangerment. 14. Child abuse. 15. Attempt to commit child abuse. Count 5. 1. Aggravated child neglect. 2. Facilitation of aggravated child neglect. 3. Attempt to commit aggravated child neglect. 4. Facilitation of attempt to commit aggravated child neglect. 5. Aggravated assault. 6. Facilitation of aggravated assault. 7. Attempt to commit aggravated assault. 8. Facilitation of attempt to commit aggravated assault. 9. Reckless aggravated assault. 10. Facilitation of reckless aggravated assault. 11. Assault. 12. Attempt to commit assault. 13. Misdemeanor reckless endangerment. 14. Child neglect. 15. Attempt to commit child neglect. Count 6. 1. Tampering with evidence. 2. Facilitation of tampering with evidence. 3. Attempt to commit tampering with evidence. 4, facilitation of attempt to commit tampering with evidence. Count 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. 1, false report. 2, attempt to commit false report. Count 19, 1, abuse of a corpse. 2, facilitation of abuse of a corpse. 3, attempt to commit abuse of a corpse. 4, facilitation of attempt to commit abuse of a corpse. Count 20, 1, failure to report a death under suspicious, unusual, or unnatural circumstances. And 2, attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. The essential elements for each offense of each count of the presentment have been previously set forth in these instructions. Please refer to those essential elements as you deliberate on the charged offense or lesser included offense of each count of the presentment. Fines. Excuse me. If you find the defendant guilty beyond reasonable doubt of an offense, you may, in your discretion, fix a fine in any amount not to exceed the amount listed for that offense in these instructions and on the verdict forms. If, after considering the charged offense and lesser included offenses in each count as set out above and in the verdict form, you find the defendant not guilty or have a reasonable doubt as to her guilt as to all counts and offenses, then you must return a verdict of not guilty and acquit the defendant. In considering the charged offense and lesser included offenses in each count, in this case, do not consider punishment. If you find the defendant guilty of any offenses of any count, the court will set punishment at a separate sentencing hearing. Y'all want to come up here for a second?
No, she's going to be convicted without a doubt. She could life without parole. Can you believe these jury instructions? This guy's almost been talking, or he has been talking for an hour reading. Hear how quiet that courtroom is? That's crazy.
That's why I tell you this is the original. I'll tell you. This is what it is.
It's so quiet you can almost hear their whispers.
All right. Now, ladies and gentlemen, remember, when you go back there and you select a four-person, this is the official jury charge. Okay? And I'm not going to take up your books and make a change in every one of your books and hand them back out. Otherwise, we'd be here till later tonight. So I'm going to make the change on page 48. And when you deliberate, you go by what this black notebook says. Can everybody do that? Everybody's shaking their head yes. All right. Let me start that over. If after your deliberations you find the defendant guilty of first-degree murder, we will then proceed to sentencing and you will set the punishment. If you find the defendant guilty of any offense in counts 4 through 20, the court will set the punishment in a separate sentencing hearing. You'll be provided with forms for all possible verdicts in this case, and it will be at the back of these instructions. The jury, the jury will mark the appropriate verdict on the form by checking the box next to your verdict, and your foreperson will sign and date the verdict form. Now, in your books, you don't have, oh, you may have. You have verdict forms? All right. This goes back to what I said about the original notebook. You use the verdict forms in this black notebook. All right. Verdict form count 1. We, the jury, find the defendant, Megan Boswell, mark the appropriate one. Checkbox 1, guilty of first-degree murder. Or checkbox 2, guilty of facilitation of first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 3, guilty of attempt to commit first-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 4, guilty of facilitation of attempt to commit first-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 5, guilty of second-degree murder. Fine amount $ blank, not more than $50,000. Or checkbox 6, guilty of facilitation of second-degree murder. Fine amount $ blank, not more than $25,000. Verdict form, count 1 continued. Checkbox 7, guilty of attempt to commit second-degree murder. Fine amount $ blank, not more than $25,000. Or checkbox 8, guilty of facilitation of attempt to commit second-degree murder. Fine amount $ blank, not more than $10,000. Or checkbox 9, guilty of voluntary manslaughter. Fine amount $ blank, not more than $10,000. Or checkbox 10, guilty of facilitation of voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 11, guilty of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $5,000. Or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter. Fine amount $ blank, not more than $3,000. Or checkbox 13, guilty of reckless homicide. Fine amount $ blank, not more than $5,000. Or checkbox 14, guilty of facilitation of reckless homicide. Fine amount $ blank, not more than $3,000. Excuse me. Or verdict form count 1 continued. Checkbox 15, guilty of criminally negligent homicide. Fine amount $ blank, not more than $3,000. Or checkbox 16, guilty of facilitation of criminally negligent homicide. Fine amount $ blank, not more than $2,500. Or checkbox 17, guilty of child abuse. Fine amount $ blank, not more than $2,500. Or checkbox 18, guilty of child neglect. Fine amount $ blank, not more than $2,500. Or checkbox 19, guilty of attempt to commit child abuse. Fine amount $ blank, not more than $500. Or checkbox 20, guilty of attempt to commit child neglect. Fine amount $ blank, not more than $500. Or checkbox 21, guilty of assault. Fine amount $ blank, not more than $2,500. Or checkbox 22, guilty of attempt to commit assault. fine an amount of $blank, not more than $500, or verdict form count 1 continued. Checkbox 23, guilty of misdemeanor reckless endangerment, fine amount of $blank, not more than $2,500, or checkbox 24, not guilty. 4-person signature line date blank. Verdict form count 2, with jury find the defendant Megan Boswell marked appropriate 1. Checkbox 1, guilty of first degree murder in the perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder in the perpetration of a felony, fine amount of $blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder in the perpetration of a felony, fine amount of $blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony, fine amount of $blank, not more than $25,000, or checkbox 5, guilty of second degree murder, fine amount of $blank, not more than $50,000, or verdict form count 2 continued. Checkbox 6, guilty of facilitation of second degree murder, fine amount of $blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder, fine amount of $blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, fine amount of $blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, fine amount of $blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, fine amount of $blank, not more than $5,000. Checkbox 11, guilty of attempt to commit voluntary manslaughter, fine amount of $blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, fine amount of $blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, fine amount of $blank, not more than $5,000, or verdict form count 2 continued. Checkbox 14, guilty of facilitation of reckless homicide, fine amount of $blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, fine amount of $blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount of $blank, not more than $2,500, or checkbox 17, guilty of child abuse, fine amount of $blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child abuse, fine amount of $blank, not more than $500, or checkbox 19, guilty of assault, fine amount of $blank, not more than $2,500, or checkbox 20, guilty of attempt to commit assault, fine amount of $blank, not more than $500, or verdict form count 2 continued. Checkbox 21, guilty of misdemeanor reckless endangerment, fine amount of $blank, not more than $2,500, or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 3. We, the jury, find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of first degree murder and perpetration of a felony, or checkbox 2, guilty of facilitation of first degree murder and perpetration of a felony, fine amount of $blank, not more than $50,000, or checkbox 3, guilty of attempt to commit first degree murder and perpetration of a felony, fine amount of $blank, not more than $50,000, or checkbox 4, guilty of facilitation of attempt to commit first degree murder in the perpetration of a felony, fine amount of $blank, not more than $25,000, or checkbox 5, guilty of second degree murder, fine amount of $blank, not more than $50,000, or verdict form count 3 continued. Checkbox 6, guilty of facilitation of second degree murder, fine amount of $blank, not more than $25,000, or checkbox 7, guilty of attempt to commit second degree murder, fine amount of $blank, not more than $25,000, or checkbox 8, guilty of facilitation of attempt to commit second degree murder, fine amount of $blank, not more than $10,000, or checkbox 9, guilty of voluntary manslaughter, fine amount of $blank, not more than $10,000, or checkbox 10, guilty of facilitation of voluntary manslaughter, fine amount of $blank, not more than $5,000, or checkbox 11, guilty of attempt to commit voluntary manslaughter, fine amount of $blank, not more than $5,000, or checkbox 12, guilty of facilitation of attempt to commit voluntary manslaughter, fine amount of $blank, not more than $3,000, or checkbox 13, guilty of reckless homicide, fine amount of $blank, not more than $5,000, or verdict form count 3 continued. Checkbox 14, guilty of facilitation of reckless homicide, fine amount of $blank, not more than $3,000, or checkbox 15, guilty of criminally negligent homicide, fine amount of $blank, not more than $3,000, or checkbox 16, guilty of facilitation of criminally negligent homicide, fine amount of $blank, not more than $2,500, or checkbox 17, guilty of child neglect, fine amount of $blank, not more than $2,500, or checkbox 18, guilty of attempt to commit child neglect, fine amount of $blank, not more than $500, or Checkbox 19, guilty of assault. Fine amount, $, not more than 2,500. Or checkbox 20, guilty of attempt to commit assault. Fine amount, $, not more than $500. Or verdict form count 3 continued. Checkbox 21, guilty of misdemeanor reckless endangerment. Fine amount, $, not more than 2,500. Or checkbox 22, not guilty. 4-person signature line date blank. Verdict form count 4, we the jury find the defendant Megan Boswell marked appropriate 1. Checkbox 1, guilty of aggravated child abuse. Fine amount, $, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated child abuse. Fine amount, $, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child abuse. Fine amount, $, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child abuse. Fine amount, $, not more than $10,000. Or checkbox 5, guilty of aggravated assault, fine amount, $, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault, fine amount, $, not more than $5,000. Or verdict form count 4 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount, $, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit aggravated assault, fine amount, $, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault, fine amount, $, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount, $, not more than $3,000. Or checkbox 11, guilty of assault, fine amount, $, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault, fine amount, $, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount, $, not more than $2,500. Or checkbox 14, guilty of child abuse, fine amount, $, not more than $2,500. Or verdict form count 4 continued. Checkbox 15, guilty of attempt to commit child abuse, fine amount, $, not more than $500. Or checkbox 16, not guilty. 4-person signature line date blank. Verdict form count 5, we the jury find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of aggravated child neglect, fine amount, $, not more than $50,000. Or checkbox 2, guilty of facilitation of aggravated neglect, fine amount, $, not more than $25,000. Or checkbox 3, guilty of attempt to commit aggravated child neglect, fine amount, $, not more than $25,000. Or checkbox 4, guilty of facilitation of attempt to commit aggravated child neglect, fine amount, $, not more than $10,000. Or checkbox 5, guilty of aggravated assault, fine amount, $, not more than $10,000. Or checkbox 6, guilty of facilitation of aggravated assault, fine amount, $, not more than $5,000. Verdict form count 5 continued. Checkbox 7, guilty of attempt to commit aggravated assault, fine amount, $, not more than $5,000. Or checkbox 8, guilty of facilitation of attempt to commit assault, aggravated assault, fine amount, $, not more than $3,000. Or checkbox 9, guilty of reckless aggravated assault, fine in amount, $, not more than $5,000. Or checkbox 10, guilty of facilitation of reckless aggravated assault, fine amount, $, not more than $3,000. Or checkbox number 11, guilty of assault, fine in amount, $, not more than $2,500. Or checkbox 12, guilty of attempt to commit assault, fine amount, $, not more than $500. Or checkbox 13, guilty of misdemeanor reckless endangerment, fine amount, $, not more than $2,500. Or checkbox 14, guilty of child neglect, fine amount, $, not more than $2,500. Or verdict form count 5 continued. Checkbox 15, guilty of attempt to commit child neglect, fine amount, $, not more than $500. Or checkbox 16, not guilty. 4-person signature line date blank. Verdict form count 6, we the jury find the defendant Megan Boswell marked the appropriate 1. Checkbox 1, guilty of tampering with evidence, fine amount, $, not more than $10,000. Or checkbox 2, guilty of facilitation of tampering with evidence, checkbox amount, $, not more than $5,000. Or checkbox 3, guilty of attempt to commit tampering with evidence, fine amount, $, not more than $5,000. Or checkbox 4, guilty of facilitation of attempt to commit tampering with evidence, fine amount, $, not more than $3,000. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form counts 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, and 17. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of false report. Fine, amount $sign blank, not more than 5,000. Or checkbox 2, guilty of attempt to commit false report. Fine, amount $sign blank, not more than 3,000. Or checkbox 3, not guilty. 4-person signature line date blank. Verdict form count 19. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of abuse of a corpse. Fine, amount $sign blank, not more than $3,000. Or checkbox 2, guilty of facilitation of abuse of a corpse. Fine, amount $sign blank, not more than $2,500. Or checkbox 3, guilty of attempt to abuse a corpse. Fine, amount $sign blank, not more than $2,500. Or checkbox 4, guilty of facilitation of attempt to commit abuse of a corpse. Fine, amount $sign blank, not more than $500. Or checkbox 5, not guilty. 4-person signature line date blank. Verdict form count 20. We, the jury, find the defendant, Megan Boswell, marked the appropriate 1. Checkbox 1, guilty of failure to report a death under suspicious, unusual, or unnatural circumstances. Fine, amount $sign blank, not more than 3,000. Or checkbox 2, guilty of attempt to commit failure to report a death under suspicious, unusual, or unnatural circumstances. Fine, amount $sign blank, not more than 2,500. Or checkbox 3, not guilty. 4-person signature line date blank. Back on page 48. You'll be provided with, well, I just did that. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. I'm going to stop right there. Is there lunch here? Your lunch is here. I'm going to let you go eat. I want you to take your notebooks and sit them on your chair and leave them out here. I'm going to have you go with the officer, eat lunch. When we come back, the parties will argue, then I will finalize the charge.
Everyone stand, please.
Does anybody know how long they're going to be on break? He read for an hour and 20 minutes. That's right, an hour and 20 minutes. Okay. Hold on a minute. Why isn't that working? Hold on. Hold up. Why is everybody so quiet? Why is everybody so quiet today? Hmm. I am here barely, not just him. But there's two things I want to cover today. Besides this, I'm covering that other person that's going to be put to sleep tomorrow. I want to finish. I want to start with that guy, and then I'm going to get into my Missouri cases because we got some naughty people in Missouri. So there's that. So this is a guy that, which I'm shocked because this happened in 2004, and God, usually it's 20 plus years. Where is he? This guy right here, Robert Tabler. He's also being put to death tomorrow, along with this demon right here. And then we're going to listen to the audio of this botched, like, execution. Or actually, I can't say botched. No, I can't say botched. These are tapes that were released anonymously. Yeah. So you guys go do what you're doing, and I'm gonna go do whatever, and we'll just, whatever. If I can find something for us to do, I will put it on the screen. But till then, go get lunch, do what you gotta do. Because let's see, what time is it here? 11:19, 12:19. Let's see. When are they coming back? Okay. Cart TV don't know. They don't got it going on. Let's look at Law and Crime. They usually are on it. Come on. All right. So 1:15 Eastern time. So we got another hour. So like good people, if you could like give me a like, and if you haven't subscribed, please subscribe for more good stuff coming. Thank you. Thank you, KB. So sweet of you. That's really nice. I appreciate that. Goodbye. Can you give a brief rundown of the medical examiner's evidence? Well, the evidence is here. Let's go to it. We are going to go to the chief medical examiner. Hold on. Oh, hold on. Let me find it. And let me tell you, her attorney badgered that witness. All right. Here we go.
I'll let her say and spell it for you.
Oh, hey, looky, look at this guy. Hold on a minute. Look it. I thought this was another attorney. That is a cop. That is the guy that has pretty eyes. Okay, so everybody's on the same page here. We are going to watch the medical examiner talk about Evelyn's how she died. That's what we're going to listen to. Where's Charlotte's here? Hi, Charlotte. How are you? Can you believe that? Can you believe that? Okay, let's carry on. So everybody knows if I start talking, that was from yesterday. I'm not, you know, okay? This is a repeat of yesterday. Guys, well,
Raise your hand. State your name.
Darenka Milosnik Poljan.
You solemnly swear or affirm the testimony you're about to give is the truth, the whole truth.
okay, this
I do.
is going to be emotional, this part.
Doctor, good afternoon.
Good afternoon.
If you would say and spell your full name for us, for the record, please.
My first name is Darenka, spelled Darinka, and my last name is Milosnik Poljan. Milosnik is spelled Mileusnic. Poljan is Polchan.
Thank you. And where are you employed?
I'm the chief medical examiner for Knox and Anderson counties and the chief medical officer for the Regional Forensic Center in Knoxville, Tennessee, and also hold the position of clinical assistant professor of actual associate professor of pathology at University of Tennessee Medical Center in Knoxville.
And how long have you held those positions?
I've been acting chief and chief since 2008. I've been in Knoxville since 2002.
What, if you would give us a little bit about your education that allows you to hold those positions?
So I graduated from medical school, University of Rijeka, RIJEKA in Croatia. It's a 6-year medical program with the last year of internship because it's a different kind of system of schooling in Europe. And then I stayed at the same university teaching medical students and doing research for approximately 4 more years. And then I relocated to Chicago area in 1991 to continue research and teach. And I joined the Department of Pharmacology and Neuroscience at Loyola University Medical Center in Chicago. And then during those research years, while I was completing my PhD, I also joined the Department of Pathology to get a training in neuropathology, anatomic pathology. That's where I spent about 3.5 years. And then after completion of those studies, decided actually to go into the field of forensic pathology. So finishing training in pathology at Loyola University at the same time as I was getting my PhD actually enabled me.
Getting a degree is important to me because I feel like I'm setting myself up for future success. The more I can learn and grow as a person and
Anatomic pathology and forensic pathology is kind of dual certification.
All right. And so what is it that you do as a forensic pathologist?
So in the state of Tennessee, actually, the forensic pathologists are medical examiners. And so because we don't have a coroner system, we have a medical examiner system, we are appointed to perform the duties of a medical legal death investigation on a county level. So essentially that's what I do. I investigate with the help, of course, with the rest of the staff in the office. Everything that was available when I was approached to originally look at the case, and I can list all the entries that I compiled in my report if that's
Sure.
Acceptable. So what was available to me at the time of review and writing of my report is a birth certificate for Evelyn Boswell, Indian Path Medical Center birth records, Premier Pediatrics medical records, Mountain States Medical Group Urgent Care medical records, Bristol Regional Medical Center medical records, then autopsy report performed and signed by Dr. Schmidt, autopsy photographs, scene photographs, TBI forensic biology reports, several of them. They were dated from March 11, March 25th, April 22nd, and then TBI toxicology report dated March 19th, that's 2020. And then National NMS, which is the National Medical Toxicology Lab, both technology forensic case report, summary of facts by the Attorney General's office, and the presentment State of Tennessee, Sullivan County Criminal Court case S72869.
And these materials, are they typical of what you would normally review in preparing an autopsy?
Yes.
All right. And based upon your review of those materials, did you form an opinion as to the cause and manner of death of Evelyn Boswell?
Yes.
And what was that opinion?
So my opinion was that Evelyn died of asphyxial death and that the manner of death was homicide.
All right. And again, you reviewed the autopsy that had been done by Dr. Schmidt. How, if anything, did your opinion differ from what she had concluded?
In essence, actually, our opinion did not really differ much, except that in my report, and that's the kind of luxury of writing a kind of expert review report versus the just regular autopsy report, is that I specify several different ways of asphyxial death or different mechanisms of it.
Okay. And when you say different mechanisms of asphyxia, what are you talking about? Can you explain that to the jury a little bit?
So asphyxia essentially means that the ability of a person to breathe or for the oxygen to be supplied to the cells in the body. And the different ways how that can occur is either by preventing the circulation to the brain or other organs and tissues in the body, or preventing the breathing, or putting a person in such a position that essentially compromises both circulation and breathing at the same time, with the end result of essentially depriving the tissues and organs of oxygen. And then in with that respect, actual asphyxial death in general are very complex deaths. And if there is any compromise in the integrity of the person, such as decomposition, then they have to be really described in such a manner, these mechanisms, that are understandable, because in the end, the asphyxial death is what we call diagnosis of exclusion, meaning when everything else is excluded, what we are left with essentially is that the findings in the body and the finding of the body within the scene that are going to come to essentially explain what really happened to an individual. What I'm essentially saying is that there's the asphyxial mechanism such as positional, mechanical, traumatic, or actually can be also the consequence of the positioning in the scene. And that information comes strictly from the scene investigation.
All right. And let's talk about each type of mechanism in regards to this particular case. What about the scene or the the body would relate to positional asphyxiation?
So the forensic autopsy, just like any other autopsy, which is a major procedure, kind of cross-section and dissection procedure in a body, almost like a complex surgery, cannot be done in a vacuum. It has to be done in the context of the scene investigation. So that's why we have medical legal death investigation, and that's why medical examiner and representative goes to the scene in order to create a context in which this individual was found. And that's why I always say that the forensic autopsy cannot be performed in vacuum. It has to be performed in the context of the scene. And then that's how essentially we approach this particular case, whether Dr. Schmidt or me reviewing it, is that in the context of the case, we have an individual who is now wrapped in multiple layers, so we can talk about it in a minute, who is positioned upside down in a confined space and in a position that prevents essentially breathing. And that's why I say the components of positional asphyxia, that's being upside down in a contorted kind of letter S position, mechanical asphyxia with the different objects essentially covering the individual's face or the body, and then traumatic asphyxia because of the positioning that is going to prevent the movement of diaphragm and breathing. And then, as I said, finding the individual in a trash can essentially creates a confined space, which is going to lead to.
Have you ever had a micro-infusion facial? This revolutionary treatment is typically performed in med spa.
Confined space asphyxia, and that's why essentially that's where I listed all these 4 different categories of or mechanisms of asphyxia.
All right. Could I see exhibits 19 through 38, please? Dr. Malisnik, I'm going to show you what's been previously admitted as exhibit number 19. If you would kind of tell the jury what they're looking there and how what they're seeing relates to the mechanisms of asphyxia.
Can I show on the screen? Or,
Is there a pointer up there? It looks like a
there's
flashlight.
a pointer?
Yes, if you don't care.
So what we are seeing is the trash can with the a child in a trash bag with the several layers on top of her, one of them being the blanket. That's essentially when, and that's how we all approach the scenes, is we go layer by layer, slight kind of uncovering the individual, whether it's adult or a child, in a similar fashion, because we don't want to lose any evidence, number one. And number 2, we want to show all the kind of components of that asphyxia by approaching it in this layered fashion. And then we can see the body of the child in an unzipped kind of onesie and in upside down position with some of her body parts showing up. So essentially, when I was telling you originally positional asphyxia, she's upside down, and we humans cannot breathe like that. There's a confined space asphyxia because of the trash can and her head being all the way down. Mechanical asphyxia because several different layers covering her face, which we'll analyze in a minute. And then traumatic asphyxia just from her body being in like a kind of reverse S position, totally crumpled and compressed in such a way that she could not breathe. There is no expansion of the diaphragm or movement of the intercostal muscles between the ribs that allow us to breathe in a position like that.
Now I'm going to show you exhibit number, previously admitted as exhibit number 30.
So on this exhibit number 30, that's actually now several stages down the investigation path. So the key is always, as I said, as little manipulation as possible, and then go again layer by layer. We lost several layers here: the garbage can, the trash can. There was also, the trash bag. There was also a black bag on top of all of that. That was all removed, and now the child is in the blanket, and there is a foil, which is actually very curious piece of evidence because it was so tightly applied to the child's face and upper body that looked like a wrapped, almost like part of the kind of mechanism that prevents her from breathing, because that would be another kind of example of mechanical asphyxia because an object is covering the face and preventing her from breathing. And the other thing that can be also seen is that the body is actually contorted. And usually that would happen, with kind of force applied because we know now she's upside down, and the force applied for her body actually to kind of fit in the bottom of that garbage can, and that would be part of the traumatic asphyxia component.
Now I'm going to show you Exhibit 31.
So this exhibit 31 actually is kind of process of removal of the foil, because it was very voluminous and it was tightly applied to her face and the hair. One thing that actually happens with the decomposition of the body following a prolonged time interval after that is that a lot of our tissues start to actually break down and detach. So the hair starts detaching, the epidermis, first layer of skin, starts detaching. And so removing foil like this that is tightly applied actually takes a lot of time and a lot of effort to preserve the child and the facial features. And part of the problem was not just the tight application, of course, of the foil, but also all the composition fluid that kind of almost created a glue between the foil and the face of the child. And we can see her head starting to emerge in this particular area.
All right. Doctor, if you could talk a little bit about the decomposition. Is there anything as far as what you see there that would show you how long the child had been in that position, or anything based on the amount of decomposition?
So the only thing that we can say really that it was advanced decomposition, and there were two types of decomposition that happened in this particular situation because of the position that Evelyn was in. The upper body, which was actually head first in the trash can, actually changed in form of so-called wet decomposition. That's why there's a lot of staining, and the decomposition fluid kind of staining the blanket and the foil. Because all the fluids and everything that accumulated after that are now creating the environment for so-called wet decomposition. But then the rest of her body, which we'll see later, that were kind of up, the feet and legs, they underwent so-called dry.
They need to make her look at what she did to her baby girl. No, she's going to have her hands over her eyes. No, she should be looking.
Decomposition, or actually more kind of mummification. So the only thing that we can say it's advanced, but how long really it took, it really just depends on many factors such as temperatures around that body, and of course on the layers applied on the body surface, because that will prevent some of the flies or some other predators from coming to the body and expediting, fastening the decomposition.
Okay. And did you notice that in this particular case, you mentioned the flies and the larvae?
Yeah, there was some pupae, but did not really have like a direct access necessarily to the body, so there was not a lot of the maggot or activity at the time of her discovery.
I'm going to show you Exhibit 32.
So the exhibits 32
Yes.
is actually just another kind of painstakingly removal of all the layers. Again, the foil is being further detached, and now we can see her head and face, and then part of the upper body, her arm, while the legs are still covered.
Does this photo show anything in regards to the positioning of her head as it relates to asphyxia?
So one thing that what was becoming evident as the body was being uncovered is that her face was flattened because it was pressed against the foil and the blanket and the side of the trash can. And then, of course, it was also kind of a little bit contorted because the face is pointing in this direction. And then her neck was kind of slightly contorted, and the head actually is almost at the level of her buttocks. Essentially, her feet, buttocks, and head, they're all kind of compressed, almost at the same level now.
Now I'm going to show you exhibit 34.
So the exhibit 34 now shows the, it's kind of similar phase after the foil is removed. The blanket is covering the face, so the face is in this particular orientation. And again, the difference between all the fluids and wet decomposition staining the blanket versus just dry desiccation of the arm and then feet. So two kind of different processes happening at the same time, wet decomposition and dry decomposition or mummification.
Anything that you could tell in regards to, I know that the foil's been taken off in this particular photograph, but in regards to the positioning of the foil and the blanket as well, is there anything you could tell as far as whether that was haphazard or intentional?
Well, the child appeared to be wrapped, so that would show intentionality, because it's not that she was just put in a garbage and then blanket on top of her. She was definitely wrapped in a blanket, and it took a while to actually remove all the layers and unwrap her. So
Okay, guys, give me a minute. I'm going to come out of StreamYard. I want to find out why we are glitching like this. Hold on. Hold on. All right, I'm back. Let's see how it goes now. I don't like that buffering. I don't know why it's doing that. Here we go.
Was haphazard or intentional?
well, the child appeared to be wrapped, so that would show intentionality, because it's not that she was just put in a garbage and then blanket on top of her. She was definitely wrapped in a blanket, and it took a while to actually remove all the layers and unwrap her. So the way how she was found shows intentionality. As far as the changes on the blanket, one thing that happens with the wet decomposition and the fluids kind of creating, things do become kind of slippery in a way. So there was definitely some shift in the layers from the wet decomposition. Wasn't a lot of it, but there was some. And then we will see when the blanket is removed, actually, that her face was pressed against the garbage can, because the pattern of the blanket actually remains on the face.
Next, I'm going to show you exhibit 35.
So the exhibit 35, now the layers of the blanket are further removed. So the face is still covered. So we have the face, the shoulder, her buttocks, and her feet, as I said, almost at the same kind of compressed reverse kind of letter S shape. And that's how she was presented after removal of the blanket. The blanket is still stuck to the face in this area, but that's going to be the next phase.
You mentioned this, she's in a reverse S kind of shape. Is that what you're talking about when you say positional asphyxiation?
Yes, so that would be a reverse S shape.
Next, I'm going to show you exhibit 36.
So in exhibit 36, now just removal of the blanket from the rest of the head. And as I said, it had to be done really carefully because of the layers of the skin and hair detaching at this point with the decomposition.
All right. Can you tell anything in regards to the onesie that she's wearing in that particular picture?
I'm sorry?
The onesie, the clothing that she's wearing.
Yeah, the one onesie actually was unzipped.
Oh my
and there was
God.
also
No
a
way.
diaper on the body. And that was
I'm going to email StreamYard. I'm sorry, people. It's not me. It's StreamYard.
one of the questions is that would that indicate what really kind of transpired? I mean, it's hard to tell, except that, of course, onesie was completely unzipped, which was unusual for a child who's just, let's say, hypothetically dying in her sleep.
Now showing you Exhibit 37.
So Exhibit 37 actually is now next phase. The blankets, the covering, the foil, everything is removed. The onesie is unopened, and then actually this is her kind of side in the front of the face. The facial feature actually can almost completely disappear because they're so flattened against the side of the trash can. And there was a lot of kind of pupae. There was no maggot activity, which would essentially help potentially with some timing of the postmortem interval, because from what I reviewed and from Dr. Schmidt's scrap, we didn't really see direct maggot activity, so they did not injure or damage the body to that extent yet.
And now showing you Exhibit 38.
And essentially what's happening now is that her body's kind of being unfolded. That's what needs to happen in order for the clothing items to be removed, and then for the photographs to be taken, and the autopsy to be performed. Because with the autopsy, the head has to be open, and the body has to be open in a Y-shaped manner with the Y-shaped incision, and that can only happen if the body's kind of unfolded now and for complete examination.
Dr. Malusnik, did you, as part of your review of the records in this case, review the child's pediatric records?
Yes.
Do you see anything in there that would indicate to you that she would have died from something that was medically related, any medical conditions?
No, she was considered a healthy child, and all the milestones were reached in timely manner.
All right. And what about the possibility of her dying from some sort of rollover death?
So she was not an infant anymore, so she already be in a kind of toddler stage, and I've never seen overlaying on a child older than 8 months. Actually, 6 months is even pushing it, because it's just not easy to overlay a child who can already move, flip, and it's just not that easy, even for an adult, to overlay a child of that age. And I've never had a case like that. The only overlay of a 2-year-old that I had was actually a homicide.
All right. Dr. Malusnik, are you aware whether the state of Tennessee Department of Health maintains statistics on rollover deaths as far as the age of children in Tennessee?
Yes.
And have you had an opportunity to review those statistics?
Yes.
How many children last year under the age of, or over the age of 12 months died of rollover deaths in Tennessee?
None.
How many children in the last 10 years over the age of 1 in the state of Tennessee died from rollover deaths?
We all of those we call like unsafe sleeping environment. That's a none of the children who died of overlaying, rolling over, unsafe sleeping environment were older than a year.
Thank you very much. If you would answer any questions Mr. Scott has for you.
Here we go.
Good afternoon, Dr. Lewis. How are you?
Good afternoon.
My name is Gene Scott. I represent Ms. Boswell. First thing I want to ask you about is you did not conduct this autopsy.
No, I did not.
You had no physical contact with the body of this child. You didn't go to the scene. You simply reviewed what Dr. Schmidt had done. Is that correct?
I reviewed what she did and all the pertaining documentation.
And accordingly, had Dr. Schmidt have made some mistake, it's very possible that could be incorporated into your work as well.
That's a very complex question. I cannot answer yes or no. May I explain?
Sure.
So the point of having an autopsy report is to objectively describe the findings. And then the only subjective part of the autopsy report, the conclusion as to what happened, that's essentially Dr. Schmidt, in this case, conclusion as to what the child died of, cause and manner of death. So the objective findings, such as photograph, tissue sampling, should be part of the description of the case that should not be influenced by one's opinion. Now, my opinion is going to be based on those facts. Now, my opinion is going to be based on those facts plus the scene investigation. So the question was, if Dr. Schmidt made a mistake? She made objective observations and put them in her report, are corroborated with photography and tissue sampling. So anyone reviewing the case can come up with his own conclusion as to cause and manner of death. So if she made some wrong observations that are mismatched with the photographs, autopsy photographs, scene photographs, then I should be able to notice that and comment on that, but I haven't noticed any mismatches. So essentially, her conclusion as to the cause and manner of that is that's her subjective thing. I followed my own kind of line of reasoning and conclusion reviewing based on not just her report, but the scene photographs and autopsy photographs, which are documented for posterity, and anyone can review them and come up with the objective kind of conclusion as to cause and manner of that. So the short answer would be, if she made mistaken observations, I should be able to identify that in the photographs, and I didn't.
Were there photographs of the internal organs?
The photographs of the internal organs were not available. We frequently don't take those during autopsies, but we do sample organs to look under the microscope, and that was done.
Okay. Now, you described this was a diagnosis of exclusion. Can you explain what that means?
So by saying asphyxial deaths are frequently diagnosed exclusion means that we found an individual in a position that prevents breathing, but there is no mark on the body. And I've done thorough investigation. Unlike in this case, there are plenty of marks on the body. But what we say with the diagnostic exclusion, for example, is that if I have a drowning victim, I have absolutely nothing else on the autopsy, no heart attack, no evidence of seizure, no evidence of trauma, no evidence of drugs. Well, the only now conclusion is that I excluded everything else, and therefore drowning as a part of the asphyxial death is the cause of death. So that's what I meant by diagnosis of exclusion.
Okay. In this case, as it relates to the medical reasons contained in the autopsy, and I'm not talking about where the child is found at the scene, but the medical conclusions, were you able to come up with a cause of death?
So there was no other reason for this child to be dead because there was no evidence of an infection or tumor or anything like that was identified at the time of the autopsy. And the review of the medical records, which is always mandatory for forensic pathologists to review medical records, birth records, pediatric records, did not indicate that anything was wrong with the child, such as seizures or anything of that sort. So this child had no objective way or reason to be dead. And as I said, the tissues were sampled, and even with the composition that sets in the organs, if there is some major infection in the body, it would have been identifiable, and it was not there.
Okay. What is sudden infant death syndrome?
Sudden infant death syndrome is actually an abandoned, antiquated term that was used to describe sudden death in a child that essentially had negative autopsy findings and negative scene investigation, which means that we don't use the term anymore. That was an antiquated because it was never a syndrome. It always, syndrome means that there is a constellation of symptoms, findings, and signs that would kind of create this entity that one can actually have the reason for this person to be sick or dead for that matter. So there was never a syndrome. It was never a constellation of findings. What it meant actually is that we didn't find anything at the autopsy, therefore it's kind of this SIDS, nebulous diagnosis Now we actually know with the scene investigation and the advances in our field in forensic pathology that those situations where death is with no findings at the scene or in the autopsy are extremely, extremely rare. We call them sudden unexplained death in infancy, or SUDI. So that's a new term that we use. And I can tell you with the proper investigation, the proper scene investigation, proper autopsy, and proper ancillary studies such as microbiology, histology, toxicology, the rate of those SUDI unexplained deaths is extremely, extremely low, actually almost non-existent.
So you're telling me that if another pathologist said this child could die of SIDS, they're just wrong?
Yeah, he's wrong, or she is wrong, because SIDS doesn't exist. SIDS never existed. So if that pathologist is using the term SIDS, that pathologist needs to go back to forensic school.
Probably
because that
not
doesn't
competent.
exist. I'm sorry?
Probably not competent.
If he
Wow.
or she's using SIDS, that's
Oh, wow. Do you see what he's doing here? He's talking about that medical examiner that was just there. And oh, wow. This is dirty.
not a competent pathologist. At this day and age, that's not a competent pathologist.
What did you call it? The new syndrome?
But it's actually not really a syndrome. It's a sudden unexplained death in infancy or unexpected death in infancy. It means that we exhausted all the investigative capacity and thoroughly done autopsy with sampling and ancillary studies, and we found absolutely nothing.
How do you rule out that this child couldn't have died from a laryngeal spasm?
Because laryngeal spasm needs to have a reason for that to happen, and I've never had a case of laryngeal spasm in a otherwise healthy child. And laryngeal spasm is basically something that somebody would give a diagnosis or the reason for a child to be dead when they're really trying to kind of come up with stuff and create some new category. That's pretty much it.
Gastroesophageal reflux, that can lead to a laryngeal spasm, can it not?
But that would not.
Yes or no, can it lead to that? And then explain.
That's actually not something that is described in the forensic pathology field. Laryngeal spasm would not necessarily kill a child.
But could it kill a child?
I've never seen it.
Could it?
I've never seen it.
In Dr. Schmidt's report, she states that the possibility that the decedent was alive when placed in the trash can cannot be excluded.
That's correct. That's what she stated.
Okay. Is that your opinion as well?
I believe she died in the trash can.
You have no proof to show she was alive when she went in the trash can.
I have all the proofs of her not being able to breathe once put in the trash can.
Doctor, you don't know if she was breathing when she went in the trash can, do you?
She would not be able to breathe no matter what. And as I said, because of the composition, of course, we were a little bit handicapped as far as being able to completely examine all her tissues and organs. But there was no reason for this child to be dead, other than being in the trash can and being able to breathe.
You can't say conclusively she was alive in the trash can, can you?
She doesn't have a reason to be dead. And I never had an autopsy on a child older than 1 year old for no reason to be dead, except that she could not breathe in that particular position where she was placed.
Yes or no? Can you say conclusively that she was alive when she was placed in that trash can?
She could not breathe in the trash can. So that's my main conclusion.
Are you refusing to answer my question, doctor?
No, I'm just saying that the child could not breathe in the trash can.
And I'm asking, if I may, yes or no, can you say conclusively she was alive when she was placed in the trash can?
No, she might have been dead because her foil was on the face before being placed in a trash can. She could have been dead because she was put in a plastic bag before she was placed in a trash can. Obviously, the foil, the bag, 2 bags, the blanket tightly covering her face would prevent her from breathing. So all of those things had to happen before she was put in a trash can. So all I'm saying is that all those components, could have they actually brought her to brink of being dead before being put in the trash can? Sure. The trash can definitely did not help.
You can't say conclusively she was alive while she was wrapped in that blanket or tinfoil, can you?
She would have definitely died with a tin foil and the bag and the blanket. And there was no reason to put all of those things and tightly apply to her face and her body unless she was alive.
You can't say conclusively that she was alive when she was wrapped, yes or no.
All I can say is that she cannot breathe with a foil,
Judge, I would ask
with
you
a
to
bag,
ask the
bag
witness to
and
answer
with
my
the blanket.
question, yes or no.
He's asking yes or no questions. You can explain afterwards if you want to. If you feel the need to.
He just needs to go sit down. That's what he needs to do.
So I'm sorry, what was the question?
You can't say conclusively that that child was alive when it was wrapped in the blanket and when it was wrapped in tinfoil.
I have no reason for this child to be dead.
Yes or no, doctor?
And nobody can tell exactly the state of her body except that she cannot breathe with a foil and the bag. and
Judge,
the
I
trash
would
can and
ask the
blanket.
court to instruct the witness to answer the question, yes or no, and then explain.
I'm not really sure.
Let me mean. If he's asking you a question, the answer is either yes or no.
It's not a yes or no question for her.
To the best of your ability. Answer yes or no. You'll have an opportunity to explain.
For a forensic pathologist, it's hard to answer that question, yes or no, but nobody can guarantee or say with certainty what really happened to this child prior to the foil being put on her face.
So you can't say whether she was alive or dead, can you?
She has no reason to be dead, other than
Judge,
that.
this witness is being evasive. May we approach?
Oh my God. You need to sit down, Mr. Scott. You're being very, very disrespectful. Like I said, I'm no doctor, but what did I say? It's not a yes or no for her. Okay. And why is the judge letting him be mean like this and rude to the witnesses? Because this doctor has seen many deaths, right? Oh, did he get his way again? I'm really mad. I emailed StreamYard. I'm like, I'm live right now and it keeps buffering like really bad. Yes, you missed it. It was yesterday. That's what we're watching right now.
All right. Let me see if I can boil this down. The lowest common denominator. He's going to ask you this question one more time. And I understand this case and this situation. Ma'am, I'm telling you, if the answer is not yes or no, you'll be facing contempt of court. Can I be more clear?
Yes, sir.
Ask me a question.
And yes or no, can you say conclusively that this child was alive or dead when it was placed in the blanket and the tinfoil?
The blanket, tin foil, the trash can, which one? Okay, the answer is no. She could have been murdered differently.
Thank you, doctor.
He just needs to sit down. Okay. Hello. I was super busy yesterday. I got a free membership to American. So I was working on stuff with that mental health. Okay. All right, let's see what's going on. They should be back here, but they probably are. Of course not. No. Justice is coming, baby girl. Justice is coming.
Evelyn. Hi. Mm. Mwah. Mwah.
Sweet little girl. I got to go on court TV on the TV and it says closings are next. Yeah. Yes. Yeah. We know that. Silly. I always wonder what happens when they meet in the afterlife. Ew, I don't know. Where's Misty? Misty's back? Where is she? There she is. See, that's what I want to know. I want to know what happened. First, she's trying to blame everybody, right? But they really focused on Hunter, and yeah, and then next thing you know, if it was Hunter, then they're talking SIDS. Okay, this baby was 13 months old. She was wrapped up with foil, a blanket, a trash bag, put in the trash upside down, and her body, your body, what is it called? She was there for what, 3 months? Maybe 3 months. And the doctor said, did you hear that one part of her face was flat? And, decomp and all that. But ain't that horrible? Can you imagine those people that are looking at those pictures? Can you imagine? I hope the prosecutor shows pictures of the baby alive and well. For closing. They probably won't because, yeah. Cray Megan snapped after she thought, I think, well, she didn't have a chance in life, just like she didn't give her daughter. But I think, hold on a minute. Here. I think that was all cool. Let's have a baby, right? Then the baby gets older and it's more to work, right? And she's still young. She was 17 when she had her. Okay, now she's 18. And I'm saying when this happened and she got a new boyfriend because she every few months she had a different boyfriend. And so little baby Evelyn was in her way, but you hear how many people love that baby. She could have brought the baby to. But no, she sat there and lied to everybody. Everybody. She's so good. Those lies just flow right out of her mouth. Just amazing to me. I mean, come on, look at FBI, TBI, the county sheriff, the state, all different FBIs and special agents and stuff. Crazy. So, like you people thinking that little Summers' parents have anything to do with her, you're wrong, because you know what? They're not smarter than the Secret Service, the FBI, okay? The TBI, right? What's going on? Who's that? I don't know who that is. Enlighten me. Oh boy, guess what? The Florida Department of Corrections. Let's see. How much more? Hold on. Online payment. All right. People. Let's see. All right. Ooh, this is going to be good. All right. I'm going to go pay for it now, people. I'm going to go pay for it. Hold on. All right. Give me a minute, people. Holy crap. What is going on with that guy? Yeah, I am. I gotta pay first. But I already got the I'm on the website right now to pay. Oh, I know you do. We have talked. I know you do, dear.
So we need to address that.
You need to plan at your table. You don't want me to stand right here?
I don't want you to cross.
I may stand right here.
Can't stop you from standing right there. I won't stand in front of you, but I don't want you crossing the end of the table.
Why?
My face.
Judge, we may have to have a sidebar before we start.
That's not what I said. Just quick approach. I'm always approaching. Those of you standing on the back wall, I can see you very close.
You mean like this is the table to cross it? No, I'm not doing that. I'm like, you meant don't step back over there.
No, you can, I think you can stand anywhere you want.
Okay, I thought, I misunderstood you. Oh.
She goes to the second.
Well, the problem is that laser stream right now, because it's made for LCD screens, it bounce off. I don't know what he was intentional. Yeah. Yeah. Well, and he moved it, practice with it to make sure it worked, and it was hitting the wall over there when I was trying to keep it. She sure did. She told me.
All right. Is the state ready to proceed with closing?
Yes, Your Honor.
Defense ready?
Yes, sir.
If the jury's ready, let's bring them in. Now, I am going to say, hey, Kyle, hold on.
Okay.
Sorry. We put this down here so y'all can hear me. Can everybody hear me? If there's any outbursts at any time during the state's closing, the defendant's closing, the state's rebuttal, I'll clear the whole courtroom. All right? Now we can jury.
I don't care for that judge. I don't. I'm trying to went missing where 5 passed it. Yeah. What is what about it?
It's 1.5
That's a horrible thing that happened.
separated, right? 93 also.
Here we go. Here we go. Boy, I'm telling you, remember I told you guys I wasn't happy with the Florida DOC because me wasting all that money for 4 pieces of paper. But I got more coming.
It's a video.
It's bad when it's one of the security officers. Huh?
Everyone stand, please.
I'm going to leave this up if that's okay, Your Honor.
Right.
Thank you. So we've finally reached the point in trial for closing arguments. And what this essentially means is it's an opportunity for the state of Tennessee to go through, talk about the evidence a little bit, reflect on some of the witnesses, because it's been a pretty long, almost 2 weeks. The state will go first, then one of the defense attorneys will have an opportunity to go, then the state will go again. And Matt, I'll talk a little more about that in a second, but that's because the state carries the burden of proof. So I think each of you should have a jury instruction pamphlet in front of you. I'm going to ask you if you flip to page number 6, it covers the burden of proof. And it seems like it's a common misnomer for the burden of proof to appear to be higher than it actually is for the state of Tennessee. And don't get me wrong, it is a high burden, and we gladly carry that burden every step of the way. But when you read about reasonable doubt, and that, of course, the burden never shifts to the defense. The burden is always on the state of Tennessee. It is a burden. It's not absolute certainty. It does not require you to say, I don't know 100% what happened. That is not what is required by the law. It is not absolute certainty. It's essentially, can you go to bed and let your mind rest easy? Can you, actually, I'm going to do one other thing real quick. What I'm asking you to do is essentially use your own common sense. That's one of the most important things. Okay. And I'm going to give an example of what I mean by this, if I can. It's like Wheel of Fortune. Okay? My handwriting's not the best though. But you get the idea here. It's like Wheel of Fortune. When you see a contestant on Wheel of Fortune and they know the answer to the phrase or the statement, they don't have all the letters when they see that phrase, but they know what the answer is. And if the state has done that, we have met our burden. And it's important to note that it's not beyond a shadow of a doubt. It's not absolute certainty. That is not what is required by the law, by the state of Tennessee. So that brings me to some of the arguments that Mr. Scott has made through this trial. They might be on that same page. Probably should have written it. Here it is, page 5. In your instructions, in the second paragraph, it states, statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. And I beg you to remember that. When Mr. Scott gets back up and makes his arguments, remember that. The things that come out of his mouth and that came out of his mouth during trial, that is not the evidence. He tried to get you to speculate on so many things during this trial. He wanted to throw out strange theories with aluminum foil. He wanted to throw out a term that doesn't even matter anymore, SIDS. That came from his mouth, not either of the doctors, but from Mr. Scott. He's asking you to speculate. That is not evidence. I beg you to only think about the items that were put into evidence, the photographs, the recordings, and what came from the witness stand. Do not let them sway you from what actually happened in this case. He kept mentioning cadaver dogs. He wanted you to think about that. But if you remember the cadaver dogs, Tommy Boswell, on his property, what did we hear him say? The cadaver dogs didn't even go up there by the playhouse. He wants you to believe maybe the body wasn't there at that time. He's trying to throw you off, but he didn't show anything. There's no proof. There's no evidence.
Look at this guy. He's always so angry. I think he needs blood pressure medicine.
Ladies and gentlemen, I want to remind you once again, and it's in here in these instructions, but the defendant has no burden to prove anything during this trial. The burden is wholly on the state of Tennessee. Okay? Go ahead, Jim.
Thank you. And I believe I said that. The state, we gladly carry this burden. But again, what comes out of Mr. Scott's mouth is not evidence. You heard nothing from the witness stand about cadaver dogs. There's no piece of evidence about cadaver dogs. And Mr. Scott said in his opening statement, humans make mistakes. Do you remember that? Dogs also can make mistakes. And if you remember, Agent Fraley and Agent Gratz, both with the TBI, what did they say? They didn't smell anything in that playhouse until they lifted the black bag, and immediately the smell of decomposition hit them. I submit to you, cadaver dogs, what do they work off of? The smell of decomposition. Don't let that fool you. Mr. Scott also talked a lot about Hunter Wood. We heard a lot about Mr. Wood in this trial. Again, did we hear any witness from the witness stand that ever saw Evelyn with Hunter Wood? There wasn't a witness that ever saw Evelyn with Hunter Wood. And if you remember the text messages that we saw yesterday from essentially Hunter's own mouth, it's pretty clear that he's yet another victim of Megan Boswell. She was feeding him the same lines that she was feeding every other person in this case. Mr. Scott brought up the theory of an accident or the word SIDS. Well, you heard Dr. Malushnik say that in the past 10 years in the state of Tennessee, a child 12 months or older has not passed away from SIDS or sudden unexplained death. Those are statistics from the state of Tennessee. But somehow Mr. Scott wants you to believe that somehow that's how this baby died, even though she has foil wrapped around her head, a blanket wrapped around that, inside a trash bag, upside down in a trash can. Let's go through our timeline just for a minute. What do we know? We know that Evelyn was okay until November of 2019. We know that Evelyn was seen at Thanksgiving by family. And then Megan Boswell started a new job at the Chicken Shack. What do we know after that? Megan Boswell meets Hunter Wood. And we know that Sue Whitson is probably the last person to ever see Evelyn alive again. You remember the picture that Sue took? This is very likely the very last picture of Evelyn Boswell alive. Not taken by Megan Boswell, but taken by the babysitter. Sue Whitson testified that the last time she babysat was the end of November, early December, which just so happened to coincide with when Megan Boswell met Hunter Wood, a guy that she was hoping might change her life. But Evelyn was in the way. What did we hear? Do you remember Megan's friend, Maddie Broom? We heard a little bit about her. Her brother, Stephen Lawrence, tried to help Megan. She drove her to a few of the interviews. And if you remember, Megan was apartment shopping on December 8th. And on that date, Evelyn was not with her. And so Stephen asked her later, after it's been reported that Evelyn's missing, he says, was Evelyn gone by then? And what did Megan say? Yes, Evelyn was gone by then. So that takes our window from December 3rd, essentially when Megan Boswell started working at the Chicken Shack, to December 8th. Evelyn Boswell's 12-month well visit Do you remember that? Scheduled for December 5th. Megan doesn't call and cancel. She just no-shows. And Casey Saltz, the receptionist there, had to reach out and ask Megan, and Megan gave some excuse, I can't remember what it was, as to why she couldn't bring her. So they rescheduled for the next day. Did Megan show up with Evelyn the next day? No, she didn't. I submit to you, that's because Evelyn was already gone at that point. Casey texts Megan again, and Megan has yet another excuse. The appointment's rescheduled one more time for December 11th, and conveniently, Megan then says, oh, I've decided to change pediatricians. And as we can all imagine, when you change pediatricians, we all know that children have vaccine records and all of the things that come with being, especially that first 12 months of life. They've got a lot of appointments and a lot of vaccinations. So it'd be really, really important to transfer that information to the new pediatrician. Did Megan Boswell do that? No, she didn't. They never got a request from another pediatrician. That was just another line that Megan Boswell told to start trying, I say trying, to cover her tracks. We also know that on December 7th, you saw a text message yesterday from a girl named Haley Marie, and that is the very first time that Megan tells the story her dad has her. December 7th. Keep in mind, Sue Whitson saw Evelyn alive for the last time, and then Megan just stopped showing up. And then by December 7th, she's concocted her plan. And it really explains why so much time goes by, because I know that's a question we have all had. 2.5 months goes by, 2.5 months. But now we know. We know why, because Megan Boswell was telling every single person in her family and her closest friends that Evelyn was with her father. So what does a rational person think? Okay, we're glad. I think Tommy even said that from the stand. I was proud of him for stepping up. I was proud of him for stepping up and taking responsibility. But, time continues to pass, and you've heard witnesses, in particularly Bailey and Audrey, Megan's closest friends. They were all starting to talk and to think like something doesn't feel right. Just doesn't feel right. But no one could have known how wrong this was at the time. February 2020, finally, Tommy Boswell says, I've had enough. I want to see my granddaughter. Show her to me by tomorrow, or I'm reporting it to DCS. Well, Megan couldn't do that. Megan knew she couldn't do that because she knew where Evelyn was. We all know where Evelyn was. And so Megan did not produce Evelyn that day. And Tommy finally gets the ball rolling on trying to find this little girl. And they first show up at Hunter Wood's house on the lake in a nice neighborhood. And Megan Boswell's there. But there's no baby. There's no Evelyn. And you remember, the only thing Megan, you remember James Lewis from DCS, the only thing Megan was really able to show was this box from Hunter's bedroom. And you remember what Megan called that box? A memory box. Now, why would you call something a memory box if you were alleging that your child is still alive? This is all Megan Boswell had of Evelyn in that house that she was trying to show DCS that Evelyn was living in. She couldn't show him diapers. She couldn't show him a pack and play. She showed him one outfit that she held up on a hanger, not an outfit that Evelyn had ever worn. There was no evidence that a child had ever been in that house. Now, I'm going to touch on something briefly. If you remember Paul Durant yesterday, going back and trying to just give you a little bit of a timeline. If you remember, he talked about Ethan Perry in the military because Megan Boswell led him to believe that he was the father, even though he had his doubts. She convinced him that he was the father of Evelyn. We know he was not the father. We know that. And he said she was sharing photos daily, constantly sharing photos. Until what day? Do you remember the date? December 3rd. On December 3rd, Megan Boswell stopped sharing photographs of Evelyn. And she continues to send pictures, but if you remember, Agent Durant he's a smart guy. And so he was able to check her full Facebook extraction. And so she continued to send pictures to Ethan, but they weren't recent pictures. It was just another way that she could try to keep this facade going just as long as she could. Mr. Scott wants you to believe that Megan Boswell had a rough life. She was in foster care. But Megan Boswell was in foster care because of Megan Boswell, because she would not go to school. She went to foster care because she was truant. And when she left foster care, she went and lived with her dad. And of course, Evelyn was a baby at this point. I think the testimony was from February to March of 2019. And then her dad said, I'm going to get her a trailer, set her up. He bought her a brand new car, buys her a trailer. He's giving her everything she needs to raise this child. And she goes and lives with Amani, her grandmother, from April until October of 2019. And then finally into the trailer from October to December. I think it's fair to say that she did not live in that trailer with Evelyn for very long. But in that short period of time, this is what she was able to do to that trailer. Can we look at that for a second? That's what she had her child living in. If that's not neglect, she does this in 2 months. Ladies and gentlemen, I beg you to look at these pictures when you go back in the jury room. That, in 2 months, is what the defendant was able to do to the home her dad provided for her and her child. And within 2 months, Evelyn was dead. And I stated maybe it's just my opinion, there are a lot of victims in this case. Bailey Hawkins, her very best friend. Did you see how difficult it was for Bailey to testify? To look at someone that she trusted, that she loved. Audrey Gibbs, same thing. They are also victims of Megan Boswell. And they will also suffer for the rest of their lives because of what Megan Boswell, the web that she created for them all to get caught in. Erica Stacy, who cared about Megan and Evelyn so much, is a victim. Gail Kite, the foster mother, she's a victim. Ethan Perry, who's serving his country, doing absolutely nothing other than his job, gets pulled up into Megan Boswell's web because Megan Boswell is only worried about Megan Boswell. And I'll submit to you that Hunter Wood, the person that they would like to blame somehow, is also a victim of Megan Boswell. She starts with first blaming Ethan Perry. She does that for a few days. And when she quickly realizes, gosh, law enforcement can figure out that I'm not telling the truth here, I guess I better tell something different. Then she goes to her mom. She blames her mom, her own mother. She's willing to blame all the time knowing. I mean, we know, let's find the picture. We know where Evelyn was.
Oh no, what's going on? What? Okay.
There she is. Evelyn Boswell sat there in that trash can for 2.5 months. And her mom discarded her, not just Evelyn, but everything that was associated with Evelyn. Everything. Because she didn't need it anymore. Everything. She didn't need that stroller anymore, so she left it behind. She didn't need the clothing. Do you remember all the pictures that came in and all of that stuff that was in that shed? Because she didn't need it anymore, because she knew where Evelyn was. The defense wants you to believe that Hunter Wood is the one that backed Megan's car up to that shed in the middle of the day. In the middle of the day, Hunter's just going to go over there. He has a truck. The testimony was that Hunter had a big truck. Now, why in the world, if he had a truck, I mean, this clearly took more than one trip. I guarantee you, look at all the stuff. They want you to believe that Hunter Wood backed Megan Boswell's car up to that shed that day. Tawny came home. It was in the middle of the day. Where's the diagram? Do you remember the diagram of the scene? Look at this diagram. They somehow want you to believe that Hunter Wood pulls up this driveway and comes to this shed right here, right in front of Omani's house. Tommy's house up on the hill in the middle of the day. Is that reasonable? What is reasonable? How about that Megan Boswell is the one who drove her own vehicle, the vehicle her dad bought for her, up to that shed, because Megan Boswell is the one who had a key fob. Remember, there's a gate there that only opens with a key fob. That's the only way a car is coming through that driveway. And Megan Boswell lived there. You just heard that she lived at her dad's house and at Omami's house. And so they're not going to be surprised if Megan Boswell is on the property. She's the one who dumped Evelyn's property there. She's the one who took the trash can there. Not Hunter, not anyone else. It's Megan Boswell. Do you remember there was more than one text message? And of course, keep in mind, the whole time these text messages are coming through, that's where Evelyn is, okay? Just think about that for a second. I'm not going to take the time to go through these because you can do that. You can take all of this back with you into the jury room. I encourage you to go back and read all of these text messages and remember the dates that we've talked about. But while Evelyn Boswell is sitting in this trash can and people are asking Megan, how's Evelyn? What does Megan say more than once? Mean as fuck. First of all, she's a 12-month-old child. And every other witness said that she was a lovely child to be around. And it's not a very nice statement to begin with, but it's definitely not a very nice statement when your kid is shoved down into a trash can upside down. And you know that. Agent Fraley was on the stand and you heard Megan Boswell admit that she knew Evelyn was dead. She's telling all of those stories to law enforcement. And she told more than one person, Evelyn's mean as fuck. And when Agent Grass asked her about it, she goes, what's your point? What's your point? And that's an interview with Agent Grass that you can also go back and watch if you'd like to do that. So we saw the defendant enjoyed crying during this trial because she has an audience and she really enjoys that. But did we see her crying any other time? Did we see her crying from the witnesses on the witness stand and what they told us about her? Did we see her crying in the evidence that came in? No, Megan wasn't crying. Do you think she was crying when when she filled out this apartment application with Hunter Wood, where they list 3 occupants are going to live in the apartment. And at first glance, we're like, oh, Megan, Hunter, and Evelyn. But that's not what the defendant told David Gratz. Do you remember what she told him? She said the 3rd occupant is the baby she's pregnant with because Hunter doesn't want Evelyn to live with him. Of course, we could also look at the date on that application, January 4th of 2020. And we also know another reason that Evelyn would not be living with them. Was Megan crying here? In 2020, when she posts on Instagram, so excited for our new home. You think Megan was crying when she posted that? To me, it looks like maybe Megan's just moving on with her life. As if Evelyn never even existed. What about here? Also posted in 2020. Keep in mind, Evelyn's still upside down in a trash can because Megan's not told anyone where she is. She's still spinning her lies. Do you think she sat here when she's picking out furniture for their new house? But she's sad today. She has the gall to sit here and cry today and pretend she can't look at the pictures of what she did to her child. What about this one? Proud of my baby. New 2020 High Country. Was she sad then? What about in December? Weeks after Evelyn has been brutally murdered. What is Megan Boswell doing? Does she look, maybe we should zoom in. Does she look sad here? Maybe she is. Sure doesn't look like it. Her kid's upside down in a trash can. She's going to the aquarium with her new boyfriend. What about here? She doesn't look very sad to me. Hiking in Blowing Rock in 2020. No Evelyn. Evelyn's missing, still missing at this time. There's Megan hiking with her new boyfriend, moving on with her life. Not crying. Maybe Megan Boswell didn't have an end game. Maybe she didn't know. Maybe she hoped that Evelyn would never be found. But she had to know at some point these stories were going to catch up with her. Ladies and gentlemen, and I'm asking you today, 5 years later, February 2025, to show Megan Boswell that her stories have caught up with her. The evidence shows the defendant. This person is the only person responsible for her child being dead. You heard it straight from Dr. Malushnik. Evelyn shouldn't be dead. Evelyn should not be dead. I believe the defense brought up SIDS, reflux, rollover. I believe they even brought up a tongue tie as being a possible cause of death for Evelyn. How does that result? Any of those things. You know, he said in the beginning, the state can't even prove how she died. Are you kidding me? How does that end up with a baby in a trash can? The DNA. Let's talk about the DNA for a second. You've got the gloves that are in the trash can. And the defense somehow wants you to believe that gloves will keep fingerprints from happening. And then I guess whoever did that then took the gloves off, cut them up because they're cut up in small pieces and you can look at them when you get back there, and then dispose of them in the same trash can that the baby's in. That doesn't make sense. That doesn't make sense. And funny enough, guess what is there? Is DNA that matches Megan Boswell. that matches Evelyn. Go back through the testimony. There's not one piece of DNA, not one, that shows anyone, not Hunter Wood, not anyone else other than Megan Boswell is associated with that trash can, the evidence in the trash bags. And you heard Marla Gray, the DNA expert, talk about the mixture of DNA on some pillows that were found in the shed. And you also heard her say that that could even be from the person who made them in the factory, or it could be from the person who touched the pillow at Walmart when they were trying to decide if they were going to buy it. It wasn't even enough DNA to test. So don't be led to believe that because of that, there's some unknown stranger who did these things. Look at the evidence. Look at the evidence that's in front of you. We have evidence. We have shown you the evidence. Don't think about the speculation. Don't think about the what ifs. Look at the evidence. Some really, really good. If I could, can I see the trash can for just a second, please? Thank you. Whose fingerprints were on the trash can? Do you remember what Agent Hoover said from the TBI yesterday? Of course, he's removed the rim. He talked about how it's smooth under the rim. If you're going to carry a trash can, how do you pick it up to carry it under the rim? Whose fingerprints were under that rim? Megan Boswell. Megan Boswell's fingerprints were under that rim. If we look at Exhibit 17, can you see the black trash bag there? Whose fingerprints are on that trash bag? Megan Boswell's fingerprints. And you heard Dr. Malushnik say, and I think you can see for yourself, that trash bag's not just gently placed down into the trash can. It has been forcefully, and it's a hard image. It's a very difficult image to think about. But that's the evidence that we've been left with, that black trash bag was placed on top of Evelyn in the white trash bag, and it was forcefully pushed down. Compressed, I think, is a word that was used during the trial. And that's how Megan Boswell's fingerprints ended up on that black trash bag. Even more damning than that is the fact that Megan Boswell's fingerprints are on the foil wrapped around Evelyn's head. I would love to know a different explanation for how Megan Boswell's fingerprints got on that foil, on that trash can, on the black trash bag, except for the fact that she murdered her baby. She put her in that trash can with food trash and debris, covered her body, essentially mummified her, and tossed her away, literally, with the trash. Mr. Scott would like for you to think that the doctor's testimony, just that they shouldn't be able to just decide things in a vacuum. He kept mentioning, well, what if the child's dead on a table? And I think we all know that is not how doctors operate. Doctors operate off of medical histories and any information they can get. And that's what both doctors did in this case. They took everything, her birth records, her pediatric records, the scene itself, before they came to their conclusion. They don't operate in a vacuum. I think those were the words that Dr. Malushnik used, is they do not operate in a vacuum. And they determined what? Both doctors agree that this was a violent homicide, and that Evelyn Boswell died from some sort of asphyxiation. So, suffocation, I guess, is the easiest way to say it. So if it was not for, say, the position of her body upside down in the trash can, That could have killed her. Well, say it wasn't that. Then maybe it was the blanket that was pulled up over. Remember that? How it was tightly pulled up over her face. That could have been what it was. Or it could have been upside down in the trash can. Could have also been the trash bag that she was placed inside of, where she was unable to breathe. Could have been the foil that was wrapped around her head. Could have been the trash can itself. If you remember, the doctor testified that her face was compressed up against the side of the trash can. And her body was in a reverse S curve, to where her head was so far bent back into a reverse S because of how the defendant compressed her body down into the trash can. Forcefully compressed her body down into the trash can. Her head and neck were wrapped so tightly with foil that even when they removed the foil, you could still see the impression of the foil on her face. You could still see the trash can form still to her face. Quickly, I'm going to ask you to go to your verdict form page. And it's going to be probably at the very end of your packet. Page 50 is where it starts. So these verdict forms, I'm going to show you one example. Okay. So you'll see here, this is just for count one, and I'm just giving it as an example. We, the jury, find the defendant and mark the appropriate box. So if you go back in the jury room and you agree as a whole that Megan Boswell is guilty of first-degree murder, you do not need to consider anything below that. Those are what we call lesser included offenses, and we're required by law to put those on the verdict form for you to consider. But if you unanimously agree that Megan Boswell is guilty of first-degree murder, you can check that box and move on. You are not required to go through every single one of those if you believe that she is guilty of what she's charged with in that count. And if you go through these, you will see that each count of the indictment is similar. There are lesser included offenses for each one of these. Again, I will ask you that if you can unanimously agree, you do not need to go any further on that verdict form. The state has to prove several elements for each charge, and those are also in your packet. Count one is premeditated first-degree murder, that the defendant unlawfully killed the victim, that the defendant acted intentionally, and that the killing was premeditated. The next page defines premeditation for you as an act that was done after the exercise of reflection and judgment. It means that the intent to kill must have been formed prior to the act itself. So that means essentially when Megan Boswell wrapped Evelyn in the blanket, and you think, well, maybe she didn't have premeditation then. She could have formed premeditation in the time where she applied the foil, or premeditation in the time that she put her in that trash bag, or premeditation in the time that she pushed the next trash bag on top of her body. Ladies and gentlemen, I submit to you, there is nothing about this case that is not premeditated. Count two and count three are what we call felony murder in the state of Tennessee. That's where we allege that a murder happened during a certain felony. And these felonies are aggravated child abuse and aggravated child neglect. Again, those go hand in hand with premeditated first-degree murder. We submit to you that not only did the defendant abuse the child, but that she neglected the child. And one of the perfect examples is how she left her in the trash can. That's neglect. Leaving her in the trash can, that's abuse. And it resulted in her death, which is felony murder. And we have to prove that the child was under the age of 8. There are many counts of false report. Page 29, I think, is where it starts. And it's counts, I believe, 7 through 17. The state must prove that the statement was made by the defendant, that it was made in response to a legitimate inquiry by law enforcement, and that it concerned a material fact about the incident within the officer's concern. And if you remember, the defendant herself admits more than once that what she told the police was not true. So I submit that the state has proven each of those counts. Count 19, abuse of a corpse, page 30. The state must prove that the defendant mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, that she acted without legal privilege and acted knowingly. And I think that count speaks for itself, along with count 20, which is failure to report a death. A lot about this case really has been more about Megan Boswell than about this child, Evelyn. But Evelyn mattered. She deserved to grow up. She deserved that, but her mom took that away from her. And there's no evidence that anyone else was involved. I think you can see this was a pretty good investigation. It was very thorough, and the evidence continued to point in only one direction. The evidence only pointed at one person, Megan Boswell. She failed her daughter. She had the chance to keep her safe, to protect her, to give her to someone else if she couldn't handle her. You heard from the witnessing, there were people that she could have given Evelyn to that would have given her a beautiful life. But instead, she violently murdered her daughter. She told story after story after story for 2.5 months. And maybe the worst part is that she just went on with her life as if Evelyn had never even existed. But Evelyn did exist. Evelyn is a real person. And Megan Boswell should not be able to go on as if Evelyn did not exist. There are things we will never know about what happened. None of us will ever know everything. I think it's fair to say that we do know that Evelyn was in the way. She was in the way of Megan Boswell living the life that she thought she deserved, that she wanted to live. So Megan removed her. It's as simple as that. So today, 5 years later, almost 5 years to the day that Evelyn was reported missing, we are going to ask that you hold Megan Boswell accountable for what she did for her child. I submit to you the state has proven every count and every element of every count beyond a reasonable doubt. And we are going to ask that you return a verdict of guilty.
Thank you, General. Mr. Scott, you may close.
Good afternoon. I appreciate y'all's time. Appreciate you being here. Although I know you may not be here by your own free will, but I still appreciate it. This is a hard case. There's a lot of emotion in this case. And Amber Massengill is very good at giving an emotional closing and wanting you to play on your emotions. Jury instructions will tell you that this case is not about your emotion. It's not about sympathy. It's not about anything else. It's about proof and what's in the evidence. That's what this case is about. This case is more about what Megan Boswell didn't do than what she did do. Now, I'll go back through the witnesses here with you in a minute. But the state seems to be putting forth a theory that you should convict her of first degree murder because she didn't grieve appropriately. She had fun after her child died. Now, is it far-fetched to believe that the child died in the first part of December, like she says? No, that seems to be the point where you see Megan's personality start to change. But I would suggest to you that that change occurs when the child dies. You start to hear various friends come in and they talk. I can name them for you. Let's talk about Casey Saltz. She worked at Megan's pediatrician. And she was also technically would have been Megan's foster sister, I guess. She was the daughter of Megan's foster mother. And she talked about Megan being a good mother. She acknowledged that. She witnessed that. Megan brought her to the doctor. You have an exhibit in the records. It's item 67. It came in through the pediatrician. Read that page for page. It demonstrates that Megan was a good mother to Evelyn. She took her to the doctor for well check. She took her to the doctor when she was sick. She got medicine for her. She did what she should do. And then she misses that appointment in December. And that's when this starts. And I would submit to you, when all of this really starts, the child is dead. Now, we hear from other witnesses. We hear from Paul Miller. That is Ethan Perry's grandfather. He had no reason to believe that she wasn't a good mother. Seemed like she liked being a mom. Saw no signs of abuse or neglect. We heard from Audrey Gibbs. She'd been with Megan almost every day up until she moved to Knoxville in 2019. She describes Megan as a good mom. There were a few things. There was once where she had thought her diaper needed to be changed. Once where they neglected to buckle the car seat. But those are mistakes. That's not child neglect. That's not child abuse. Those are mistakes. Audrey talks about Megan coming to Knoxville at the end of December sometime, and by that point she acts disassociated. She's not normal. She's saying "I love you" over and over again to her. So, again, maybe she's not grieving right. Bailey Hawkins stayed at the Econo Lodge with Megan. Megan just went to sleep, despite Bailey thought they might do things. They might talk or whatever they might do. But she just went to sleep. Again, I would suggest to you she's disassociated. Bailey saw no signs of abuse, no signs of neglect. Mr. Horn questioned her. She described Evelyn as the one consistent love that Megan had. And Megan is a girl who comes from a world of fractured relationships. And Miss Massengill wants to downplay Megan's home life. Matt Price did. There's a video in there. He talks about it. He talks about, I mean no disrespect, but I know that Boswell family. I'm aware of them. I know how you come up. Your mom and daddy using drugs. I mean, you want to talk about home life? Watch the video with Agent Fraley. Her mom was let in there in stripes, a jail uniform. What kind of home life was that? And then we get to Caitlin Jones Carter, whom you can make what you want of her testimony. Her body language tells me she's no longer Megan's friend. However, she described, aside from the one day when she saw Evelyn as dirty, that Megan had been a good mother. No signs of abuse, no signs of neglect. She said she saw Evelyn sometime in December. She tried to tie it to her school, but she really couldn't give us a specific date. So I think the best you can say is that it's sometime in December. Gail Kite. Let's talk about her. Megan's foster mom. She gets Megan when Megan comes into her foster care. Megan's 7 months pregnant. She's 17 years old. Gail describes her as looking like she's not pregnant, as being underweight. We know from the medical records and the testimony that come in from Dr. Smith, Megan suffered from intrauterine growth restriction at that time. We've heard that. So that's the shape she's in. But Gail talks about how she gets her in good shape. She has the baby. She's a loving mother. She takes care of the baby. Gail never saw abuse, never saw neglect, never had any doubts about Megan. Erica Stacy, and that's the mother of Megan's ex-boyfriend, and I think his name is, can't remember his name honestly. That's the mother of his ex-boyfriend. She described Megan as a good mother. Evelyn was always clean. And I'll point something out to you. The state wants you to believe that Megan just meets Hunter Wood and throws this child away for him. She didn't do that for, I think it's Caleb Stacy. She didn't do that for Caleb. There were other boyfriends. Now there's talk about, a lot of talk about Ethan Perry thinking he was the father. Well, the proof you've actually seen is they go about as Ethan is the father. And there's been no proof that Megan knew that he wasn't the father at that point. I'm not trying to, I mean, it just happens that sometimes people may think one person's the father and they're not. But calling him out of anything or anything else. Like, it's not like this didn't start early on that she thought Ethan was the father. She obviously thought a lot of Ethan. She drove to Texas, took Evelyn to see him. Now, he did say one thing that kind of struck me a little odd. He acted as though she just showed up in Texas. I suspect, and he finally admitted on cross-examination, that he told her where he was in Texas. You just don't hop in the car and drive to Texas and say, I'll drive around El Paso so I see his car in the parking lot, pull in. That's not what happened. I think he kind of wanted you to think that, but that's not what happened. Let's talk about Randy Wood. Randy Wood is the father of Hunter Wood. The state called him. The state is the one who elicited the information about Hunter Wood being hospitalized. That's the first you hear of him being hospitalized. It's the state. Now, Ms. Massengill wants you to think I have some grand conspiracy theory. I don't. I do have a statement from Megan Boswell when she talks to Agent Fraley about what happened in this case. She says, Hunter was there when Evelyn died. I wrapped her up and I swaddled her. I held her. She kept getting colder as the day went on. I didn't want her to get cold. Hunter took her and he got rid of her. Now, they want you to believe that that's just impossible. Why did Hunter not give his DNA? Ask yourself that. If you have nothing to hide, why wouldn't you just let them test your DNA against all the evidence they had? Turns out they couldn't have tested it, probably. But he didn't give them that chance because he had something to hide. Now, his dad said that he was schizophrenic. I asked him, is he schizophrenic and have hallucinations? He agreed with me on that. He also agreed with me when I asked him if he talked about using an aluminum foil or tin foil. And he says, yeah, he talks about some off-the-wall stuff. Now, ask yourself, who's more likely to wrap that child in tinfoil? The child's mother that has cared for the child, taken care of the child, or the boyfriend who's schizophrenic? And I'm not trying to vilify Hunter Wood. That's not been my intention throughout this trial. But Megan's statement is that one of them rolled over on the bed. The young mother may think that. There could have been other causes. When we get to the causes, I guess we can go ahead and we can talk about Dr. Schmidt and Dr. Malushnik. Now, Dr. Schmidt asked her about several different things. She's the lady who actually performed the autopsy. And she formed an opinion of homicidal death based on the way the child was in the trash can. But she could not tell you a medical basis for the child's death, other than a diagnosis of exclusion. And a diagnosis of exclusion is simply, we don't know what else is wrong with her, so she must have smothered in this trash can. That's what they want, what she said, essentially. Now, I cross-examined her about a lot of things. I asked her about SIDS. And even though the subsequent doctor didn't agree with it, Dr. Malushnik, I didn't ask about something that didn't exist. Dr. Schmidt knew exactly what SIDS was. We talked about it. We talked about the ages, how we don't know what causes it. She answered questions about it. She said, ultimately, she could not rule that out in this case. Just like she could not say with any degree of certainty that the child was placed in the trash can alive or dead. She couldn't say that. She brought up that the child had a heart valve that leaked. She admitted under cross-examination that that could have been what killed the child. We talked about laryngeal, we talked about laryngeal convulsions. Could that have caused the death of the child? She admitted it could. Now, Ms. Massagill brought up tongue tie. I brought up tongue tie. I brought up GERD. I brought up an infection she had, because all of those things can lead to the onset of SIDS. That's the research, and Dr. Schmidt agreed with that. Now, I want to tell you something about Dr. Schmidt and Dr. Malushnik. I think Dr. Schmidt she was the medical examiner in Johnson City when this happened. Dr. Malushnik is not her boss. She's not, it's not like she's somehow over her. Dr. Schmidt was the chief medical examiner at the Jenkins Autopsy Center, Forensic Center. Subsequently, for whatever reason, the state sent her report to Dr. Malushnik for another opinion. Dr. Malushnik only reviewed her report, and she finds that it's a good report. But then she wants to go further and find some type of certainty that that child was placed in the trash can. And you saw an exchange between me and her in here yesterday. It went on for 4 or 5 questions. And I kept asking her, doctor, can you say any type of certainty? What can you say about this? Can you conclusively say that child was dead when it was wrapped in the blanket, wrapped in tinfoil, and put in the trash can? She evaded that question. She wouldn't answer that question. She finally answered that question only after it was threatened she would be in contempt if she didn't directly answer the question. And her answer was, no, I can't say conclusively. And then she threw out kind of a parting shot at me as she left. And suggest to you the more accuracy of that parting shot, she said the child could have been murdered some other way. Should have been. The child could have died some other unknown way. That's what the truth would have been. She presupposed that this child was alive when it went in the trash can. The doctor who did the autopsy was very clear she could not conclude that. She said it couldn't be excluded, but it cannot be included. Dr. Malushnik come in with a preconceived notion of that's what happened. Now, the state has to prove to you cause of death in this case. They have to prove that child was unlawfully killed. They have to prove this wasn't an accident. The proof from Dr. Schmidt leaves open a heart, it leaves open SIDS, laryngeal convulsion, it leaves open all of those things. We don't know what happened. It also left open a rollover, which is what Megan told Agent Fraley. And now, would Megan know for sure that that's what happened? Maybe not. You wake up and you find your baby dead in bed. Could you not come to the reasonable conclusion one of us must have rolled over on it? She's 17 years old. She's not sophisticated. She's had a hard life. She's scared that she's going to get in trouble. Hunter Wood's scared that he's going to get in trouble. And that's why she does what she does. Hunter takes the baby to dispose of it. She knows about it. Is that right on her part? No, it's not. Should she have called and reported it? She absolutely should have. I told you that in my opening statement. Have they proved that she's a liar over and over? They have. Don't deny that. They haven't proved she's a murderer. You have more counts of false report than I can really count. I think there's 11 or 12 of them. Almost every time she's talking to law enforcement, you're considering a count of false report. With the exception of, you're not considering one for the time she talked to Agent Fraley. That's not before you. I would submit to you what happened was the conversation with Agent Fraley on the 25th of February, almost 5 years ago. That was a breaking point. That's a breaking point where she finally admits Evelyn is dead. She's able to admit to herself. You saw all these pictures she's sending back and forth before that. That's how she's grieving. Maybe she doesn't want to accept that the child is dead. Maybe as long as she keeps talking about it, talking to the media, talking to the police, and saying that Evelyn is somewhere else, she believes that. Maybe that's how she's getting by. You can't judge someone for how they grieve. You don't know what goes through their head. You don't know what they were raised with. I've never lost a child. I hope none of you ever have. But how am I to tell someone when they lose their child how to grieve? How am I to do that? Amber can tell you that. Oh, she shouldn't have went here. She shouldn't have did that. How does she know that? She's not in Megan's shoes. She's not out there living in that single wide trailer. That's not her life. She's not been raised by drug addict parents, a dad that beats on her mom constantly, and seen that growing up. She's not seen that. She can't put herself in her shoes. It's not fair to say she murdered her child because she didn't grieve right. I resent it. You should too. You should look to the evidence in this case. Do they prove a cause of death? That's the stopping point on the homicide counts. They can't do it. They brought two medical examiners in here who contradicted each other. The first one at least had read her medical records. The second one talks about how she is perfectly a healthy child. She ignored everything in her medical records. She didn't talk about it. It was obvious to me. Should have been obvious to you. She hadn't read them. She didn't care. It was her job to come here and convict Megan Boswell of murder. If you don't believe that, why would she leave here and say, well, she must have been murdered some other way? She was a biased witness, and she wasn't a credible witness. Now, let's talk about the tinfoil. How can one fingerprint be on a piece of tinfoil? You all see this roll? Maybe like this. Okay, my fingerprint's on this roll. I've taken this one. The next person who gets this is going to get a piece of tinfoil with my fingerprint. That's a possible way. What's another possible way? We've heard that the tinfoil had food and debris on it. Now, there's food and debris in the trash can. But maybe the tinfoil was already thrown away in the trash can. If it came off of a roll like that, whoever got it would have had to have reached in there and gotten several pieces. There were several pieces of tinfoil. I believe 4. There should have been fingerprints all over it. One fingerprint. One fingerprint. It doesn't prove she put that tinfoil on there. Now, what about DNA on the garbage can? I would just about guarantee you, each and every one of you, your DNA is on your garbage can in your kitchen. Your DNA is all over the house. Your finger, I said DNA, actually fingerprint. Your fingerprints are all over your house. It's the kind of thing we don't think about, but you touch something, you put your prints. I think that's what you should consider. I mean, probably Evelyn's handprint on the trash can. At some point, I think in opening, I mentioned to you an unidentified palm print on the trash can. Well, I didn't know at the time it was a child's because it wasn't in the fingerprint analysis report. It's not unbelievable that it's the child's. Now, Ms. Maxengill made a statement, and I was a little perplexed with it. The state wants you, or the defense wants you to believe that wearing gloves prevents putting fingerprints on something. You heard the fingerprint expert say that it can. I think we all know that from our common sense stuff. If you cover the fingerprint up, you're not going to leave it on something. Now, let's go back to the statement with Agent Fraley. February 25th. She's talked to law enforcement over and over. And she talks about how she breaks down. She breaks. It's the breaking point. She admits she's dead. And she's telling them the truth. How do you know she's telling them the truth? Because if she's still trying to lie to them, if she's still trying to confuse them, she wouldn't have said, I don't know where the baby is. It could be at Hunter's, it could be at Tommy's. Why would you say, if you're trying to lie to them, or perpetuate this lie like Miss Maxengill tells you, that the baby could be at Tommy's? Why would you do that? Ask yourself that question. She's telling them where the baby is. She thinks, I think it could have been left one of these 2 places because I want to find it. And you'll have that video. You can watch it as many times as you want to. I hope you will watch it again. You hear Agent Fraley talk about how he'll go to the DA. She's a scared young mother. He understands that. Now, I don't have to prove this case. I wish I could, but I can't. You can't prove a negative. What I can tell you is the state has not proven their case. They've not proven the cause of death. They've not proven that the death was an unlawful killing as opposed to an accident, or some girl over in the bed being an accident, or some kind of health-related issue. They haven't proved that. Let's talk about the gloves. I go around in circles sometimes, and I hope y'all are following me. I apologize for that. But let's talk about those gloves. Ms. Baskerville talks about the criminal tore the gloves up in the trash can. I think if you'll remember back and look to your notes, TBI cut those gloves up for testing. I could be wrong, but I think that's the case. And what do those gloves tell us? Do they match up to anyone? No. But they do match up to an unknown male. There's not enough profile there to match it to someone specifically identify them, but it matches it up to an unknown male. That's why there's not multiple fingerprints on the tinfoil on the child. Those gloves that match some unknown male. We know it's male DNA. We know that. Finally, let me talk just a little bit about Hunter. There's a text thread, and it's in February. It's between Megan and Hunter. And it appears like Megan's telling Hunter the same story she's telling everyone else. But remember, Megan's told Agent Fraley that Hunter doesn't want his name brought into this. He doesn't want to be involved. He told her not to tell anybody anything about the child. At this point, Hunter, he throws out a name in that text. He talks about Agent Wilhoit. He's been involved with the police. He knows the police are looking at this. This is February the 22nd. Suggest to you that text thread is, look at the texts. They're self-serving. I'm just worried about the baby. I just want the baby returned safe. That's Hunter and Megan's way of covering Hunter's involvement in this. I'm not saying Hunter killed that child. But I'm saying he did dispose of the child. That text thread, it's a convenient way if you think about it. If you're trying to have proof that you didn't do something, if you start a conversation, start texting it, say, oh no, I didn't do that. Look at my text. I texted her, she's told me this. It's a convenient thing for him. But he didn't give his DNA. We know that. His dad talks about he went crazy because he was called a baby killer. Maybe he went crazy because of his participation in disposing of that body. We don't know. Everybody seems to agree he has went crazy. You saw a document this morning. That's where he's being held out of court over in Virginia to be evaluated to see where he's competent for some crime he's committed. He's up at Marion right now to be evaluated. That's what we know. I hope I've answered your questions. I hope my argument has helped you somehow with this case. But what I would say to you, if you have questions, about any elements of these crimes, and your questions are not answered to your satisfaction, you have reasonable doubt. If you say, I don't know how that child died, that's reasonable doubt in the homicide count. I don't think I have much more to say to you. I go to a Baptist church and I hate long sermons. I'm used to it. I think I've been up here for about a half an hour, but I thank you. I pray you'll come to the right decision. Thank you.
Thank you, Mr. Scott. General, you may close on behalf of the state.
Thank you, Judge. Ladies and gentlemen, much like Megan Boswell, Mr. Scott seems to have some very convenient explanations for what happened in this case. Lots of things that happened in this case. All of the evidence in this case that points to his client, he's got some sort of explanation for it. But the problem is, in order to buy into this, in order to believe it, you have to believe Megan Boswell. You have to believe that when she spoke to Agent Fraley on the 25th, that she was somehow, for the first and only time, in this courtroom speaking the truth. But I think each of you, as you sit here, know that's not possible. That's not possible. Megan Boswell is one of those people. You used to hear the expression, the truth ain't in them. The truth's not in Megan Boswell. She doesn't know how to tell the truth. Everything that she tells to every person in her life is for some reason. And that reason is because Megan's trying to get something out of it. She is a master manipulator. Even at 17 years old, you sit there and watch those videos. She's trying to play everybody. She's trying to play the law enforcement officers who are interviewing her. She's playing her friends. Every person in her life who walked through that gate and sat up on that witness chair was in some way manipulated by Megan Boswell. Some way. Whether it was about Evelyn, whether it was about how she was going to pay for a babysitter, whether you're the father of my child, whether you're a great grandfather, whether your wife who's dying of cancer is babysitting the kid. I mean, she knows no bounds. There is no person that she will not manipulate and tell untruths about and to. No one. But Mr. Scott comes in here today and says, yeah, hey, come on, ladies and gentlemen, the 25th, you could, that was the point, which she decided, hey, I'm going to be truthful here. No, no, it wasn't. And we know it's not. It was just another story. She was telling law enforcement to lead them some other way. That's all it was. And if you remember, Agent Gratz testified. General Massengill was asking him the question, when did this first thing about accidents and rollovers, when did that come up? Well, it came up when the police and law enforcement finally said, we got nothing going on here. We got to give her an out. We got to give her something so we can try to find this kid. So they're the ones who suggested it. And then very conveniently the next day she comes in and guess what? Oh, yeah, I forgot. Yeah, that's right. I'm sorry. I'm sorry I've been lying to you all for days and days and days now. But now I'm going to tell you the truth. But that's not what happened. That's not what happened. I submit to you, the only time that Megan Boswell may have told the truth about some small portion, if you remember during one of the interviews, Lieutenant Price, who had been very patient with her up until that point in time, finally said, come on, something happened on December 21st. And she stopped him and corrected it. Remember? She said, no, something happened before December 21st. Yeah, something did. She murdered her child. That's what happened before December 21st. Ladies and gentlemen, before I speak further about the physical evidence that ties and shows that Miss Boswell is the one who is guilty in this case and who needs to be held accountable, I want to take you back to jury selection. Last week when you all were first up here and up there, and I asked you if all of you had brought your common sense with you. And if all of you, as you listen to the evidence in the case, would use your common sense. And everyone agreed that you would. And so I want to remind you of that. And it reminds you to apply that to the evidence that you've heard, the testimony that you've heard in this case. Because the defense wants to say that perhaps, again, speculating, it's a possibility that Evelyn just died one day in early December. And then all of a sudden, Megan engages in this pattern of just totally bizarre behavior that involves wrapping her child in a blanket, tightly pressing her head in aluminum foil and stuffing her in a trash can, and then engaging in this just convoluted tale to anybody who wants to inquire about what's going on with Evelyn. But it's a remarkable coincidence, isn't it, that all this occurs at the same time that she starts working at the chicken shack. And then she meets Hunter Wood. You know, that Hunter Wood, the one who lives out on the lake in the big house. And remember, this is where Megan's living before December. These are the conditions Megan's subjecting her child to before December. Then she meets Hunter Wood. Big house out by the lake. Dad owns a business that I'm working at. Remember the other things she's telling investigators as time goes on. Needed a break. Watching 3 kids. Remember, her mom had the 2 other young siblings. Needed a break. Was tired. Wanted Ethan Perry to step up. I've been raising this kid for a whole year by myself. Probably a little bit of truth in there. A little bit of truth. But it's a remarkable coincidence. This kid, Evelyn, natural causes, just dies right at the same time. Apply your common sense in asking yourselves why. Why would Megan Boswell then start on December the 7th? She tells Bailey Hawkins, hey, it's just me. Ethan's grandma has Evelyn right now. December 7th. Remember, she starts Chicken Shack the 2nd, 7th, 5 days. 5 days later. Why does she start telling all these things that are obviously not true? I'm in a custody battle with Ethan. I don't have it. Evelyn's sick. She's got the flu. Can't bring her. Can't bring her up there to get the Christmas gifts. Let you see her. Why does she do that? Why does a mom who, by everybody's testimony, everybody's, her friend Bailey Hawkins told you, I mean, yeah, she wasn't a perfect mom, but she did well. She did well. They all did. I mean, she's posting pictures on Facebook, Instagram. Everybody. Her own pediatrician, Dr. Pugh, came in here. Yeah. She's a good kid. We didn't have any concerns. Healthy, meeting milestones, an advanced child. Why does a mom who dotes over her kid, who won't even let anybody babysit, she's so protective of this child? Remember Erica Stacy? I mean, heaven's sakes. I mean, that's an ex-boyfriend's mom who is willing to babysit the kid so that her son can go on dates with her. She won't let her do it. She won't let her do it. She will not let her babysit. That's how protective she is of this child. So why? Why? Apply your common sense. She won't do it because she can't face the truth about what she's done. She can't face that truth. She can't look at that picture, and I'm not going to put it back up there for you. She can't face what she's done to that child. Discarding her like a piece of garbage. That's what she did. She can't face that truth. So she engages in just spinning all these stories to everybody. Everybody that comes with a story, she's deflecting that out because she doesn't want to face that. It is almost unbelievable to me that the defense is still arguing that Hunter Wood had some involvement in this case. I mean, truly unbelievable to me that they're making that argument. That has no credibility, number one. And two, no proof whatsoever. Not a single shred of evidence has been presented in this courtroom that ties Hunter Wood to anything dealing with the death of Evelyn Boswell. Not one thing. It's all just rank speculation. Oh, well, because he's in a mental hospital, therefore he must have done something. Right? No. How many people walked up there, took that witness stand and said, oh, yeah, I remember when I saw Hunter and Evelyn and Megan together. I remember when I saw that. None. Nobody said that. How many people said, oh, yeah, I remember when I saw Hunter holding Evelyn at the chicken? No, again, nobody said that. No evidence, nothing from that witness stand ever put Hunter with Evelyn. She evidently wants you to believe, again, and I'll put this picture back up there. She wants you to believe that Hunter, and remember her when she's talking to Agent Fraley, that Hunter went over to her place. That's her place. Stayed the night with her and rolled over on the child. He's got a place over, nice place over on the lake, remember? But that's what she wants you to believe. When her breaking point, when she's finally telling the truth. Apply your common sense to that. What else possibly ties Hunter to this case? To Evelyn's body being disposed. Or maybe it's the playhouse over on Tommy's property. No. Again, we know Evelyn is probably gone 5 days after she first met Hunter from working at the chicken shack. But Megan Boswell wants you to believe that he's been able to go onto her property and stick a body in a trash can in a playhouse that was built for Megan Boswell. Mr. Scott asked you, and I wrote it down. He asked you who was more likely to have left a print on the foil. Well, I'll tell you who's more likely to have left a print on the foil. The person whose print was found on the foil. Megan Boswell. He stands up here, and again, we've got explanations for everything. Well, maybe it was possible she tore a sheet off earlier, and in doing that, she grabbed the foil and left a print. Well, there's no Hunter Wood prints on any of the foil. The bag that's stuffed on top of the body where Evelyn's found. Multiple prints on that. None of them belong to Hunter. They all belong to Megan Boswell. He wants to say, and again, it's still beyond my comprehension that we're talking about Hunter Wood here. You know, why wouldn't Hunter give a DNA sample? I don't know. Perhaps because Hunter is being mucked up in Megan's world here. My gosh. Here I am dating this girl, and all of a sudden I got TBI agents asking me about a child that's missing and no explanation for it. Maybe that's why. And again, in this particular case, you heard from Agent Gray. What does it matter? There's nothing that was tested. All those things she testified to yesterday, all of them, all those things I handed up to her, that she analyzed, not one piece of them had any identifiable DNA on it that could have been tied back to Hunter. None. Everything was Megan's or Evelyn's or limited profiles. As I remember, I asked her if I gave everybody in the world's DNA to her, she wouldn't have been able to match any DNA to Hunter Wood. Nothing. Nothing. Everything connected to that body in the trash can comes back to Megan Boswell. And then, let's not forget, in the middle, while all this is going on, February 22nd, Megan's child's missing. They questioned Hunter. And they had this conversation. And Mr. Scott wants you to believe that this is some kind of contrived thing between Megan and Hunter. But what evidence did you hear that there was any sort of contrived conversations going on here? Nothing. Again, nothing. In order to believe that, you've got to believe one person, Megan Boswell. And we know you can't believe her. No. Hunter says, yeah, but where's the baby? I just want the baby to be found safely. What's her response? If she was truly trying to cover this up, a little bit better response would probably be heard. She says, Dad won't let me go anywhere because of the situation. Hunter, I can't disclose stuff to you on here about what TBI is doing. His concern, please assure me the baby will be found and brought home safely. That's not a conversation with someone that you have that has disposed of a body, that has helped get rid of your dead child. That's not a conversation. Hunter Wood is not at play here, ladies and gentlemen. Not at all. Not at all. Defense has also talked to you about these things that medical conditions that they questioned the medical examiners about yesterday. Possible things that might have caused Evelyn to just suddenly die of natural causes. A perfectly healthy child. Again, he's asking you to speculate about possibilities. But we don't decide this case on possibilities. And if you think about it, ladies and gentlemen, you didn't hear from just 2 doctors about Evelyn's condition, about what kind of a child she was. You heard from 3 doctors. Her pediatrician testified in this case too. And what did she tell you? Evelyn was a healthy child, advanced, had met all of her milestones. Any concerns about her health? No, her concern was that on December the 5th, she doesn't show up for her year checkup appointment. She's a no-show. That's her concern, not Evelyn's got tongue-tied. I'm concerned maybe she's going to die from SIDS. Not, oh, she's got some sort of reflux going on. I'm afraid she might be at risk to just suddenly die one day. That's not her concern. And remember, and Mr. Scott didn't talk about this because you don't want to talk about it. I asked Dr. Malushnik yesterday about statistics. This wasn't just her opinion. These are statistics kept by the Department of Health in Tennessee about the number of kids over 1 year of age who died in rollover deaths. Entire state of Tennessee last year, none. Entire state of Tennessee last 10 years, none. But yet they want you to believe that's a possibility in this case. She's the first one, ladies and gentlemen, evidently, the first one. No, it's not a possibility. You decide this case on the evidence that you've heard, the testimony you've heard from that witness stand. And the testimony you heard from 2 different medical examiners said this child died from asphyxiation. That's what they told you. Both of them told you that. He said they had contrary opinions. They didn't have contrary opinions. One of them had a little stronger opinion, but they both had the same opinion. They both told you the cause of death was the same thing, asphyxia. And all the evidence in this case points to one person alone as being the person who caused that asphyxiation. And that is Megan Boswell. This wasn't an accident, ladies and gentlemen. It wasn't an accident at all. You've got lots of evidence of premeditation sitting over there in that box. This isn't a little piece of tin foil. This isn't foil like you stick around a baked potato and stick in the oven. You saw it. You saw the photographs, and the foil's in there. Pull it out. It's a big old piece of foil. Mr. Scott wants to suggest maybe it's sitting down in the trash can, somebody pulled it out. Nobody's using that much foil. Use your common sense. And remember the testimony from Dr. Malusnik yesterday about how that foil was applied. That blanket, so tight when they're taking it off, the impressions left on that child's face. The foil, how painstakingly slow they had to pull it off because it was tightly compressed around the child's head. I submit to you, that's premeditation, ladies and gentlemen. That's intent. That's not an accident. Part of this case, ladies and gentlemen, that as Mr. Scott said, is really, sad. It really is. It's a tragedy. You think about all those people that you heard testify, how easily all of this could have been avoided. All these people, Bailey Hawkins, Audrey Gibbs, Casey Saltz, Gail Kite, Paul Miller, Erica Stacy. Any one of those people would have taken that child. All this could have been avoided. But Megan Boswell only cares about one person, and that's Megan Boswell. She started a facade back first week of December after she killed her child. She created this world, this web, you've heard it called. That's a pretty good description of it. It's a web. It traps and ensnares everybody that she comes into contact with. She started this facade back then, and it's continued and continued and continued. And she brought it into here to this courtroom in front of you. And she's trying to get you all to believe the rollover, believe the accident, believe my child died of natural causes, and that I just flipped out and engaged in this totally bizarre behavior. But in order to do that, you have to ignore the evidence in this case. You have to ignore the forensics that place her and her alone as the perpetrator of this crime. This case is the very opposite of an accident. It's an intentional and knowing murder of a child. Megan Boswell got rid of Evelyn so that Megan could be Megan. She enjoyed it. You've seen the pictures General Massengill showed you. Hanging out on Blowing Rock, going to the aquarium, Super Bowl party. Megan Boswell sits here in this courtroom today as guilty as she was back in that first week in December. As guilty as she was on February the 18th, when she first came in there, Detective Perez, James Lewis interviewed. She acted all surprised. What are y'all going to do? You going to find my child for? What do you do when a child goes missing? Remember those expressions, those questions she threw out there? She sits here in this courtroom today as guilty as she was back then because she never learned the one lesson that we all know, which is that you're responsible for your actions and your choices in life. And she sits here because she refused to learn that lesson. You've heard her interviews. She takes responsibility for nothing. But today is the day that you get to hold her responsible for those actions, for her poor choices and decisions. for her decision to get rid of Evelyn, to dispose of her like a piece of garbage. That's what she did, ladies and gentlemen. She disposed of her child like a piece of garbage. But her poor choices and decisions have a price, and they have a consequence. The state has proven to you over the course of the last week, Megan Boswell is guilty. First-degree murder, false report, tampering with evidence, and failing to report that death to authorities. We ask today that you hold her responsible for those poor decisions by finding her guilty as charged.
Thank you, John. Have a seat, attorneys.
Okay, hey. Turn around, Megan. Come on, little girl. Turn around. Okay, could someone tell me what I can do if my ears are ringing like really, really bad, like piercing? Does anybody know what I can do, like immediately? Anybody?
Mr. Hyatt, Mr. Selner, Mr. Arnett, you're the three alternates. If you will go with the officer. Just leave them in the seat. That'd be fine. And your notes as well. We'll just take care of them. The rest, what do you mean? Yeah, I'm going to finish the charge. All right. Now, back on page 49. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. Take with you the presentment, the exhibits, the verdict forms, the court's written instructions, and you may retire and consider your verdict as soon as the officer comes back to get you. Now you go with the officer.
Everyone stand, please.
305 P.
Take the ones that you have. Just
Right.
leave the three
Leave the
back.
others.
Take the one that you took, and don't worry about the ones that belong to the others, okay? You may be seated. Thank you.
All right. We'll be in recess, waiting verdict of the jury.
All right. So there's that. So we're on verdict watch and sweet oil. See, usually it's my right ear, and my right ear I went deaf because of stuff like this. So now I'm a little freaked out because it's my good ear, and I need to figure out how to get this ringing to go away. It's really like piercing loud. Okay, so I'm gonna go. I'm gonna go for now. I gotta figure out what to do with my ear, and I'll be back later because that other man, this man right here, he's being executed tomorrow. And I want to talk about it. Where is it? Where is he? Did I take it down? Hold on. This little demon right here. Yeah, I'm thinking tomorrow. All right. I want to thank everybody who came through. I want to thank KB for the super chat. And yeah, love you all.